With regards to army barracks, my lords, in a sensitive, my lords, geopolitical sensitive zone in Siliguri, my lords. Kindly, my lords, we take this up.
Lordship, may I permit to mention this matter? I mentioned 21st July, Lordship. In this matter, Lordship, the general sawmill is installed, Lordship, and the it is a very serious problem. Lordship, the electricity bill is every 3 months is deposited, Lordship. There is a direction to opposition, Lordship. Can't as a to be mentioned, Lordship. Yes, Lordship, let it be to be mentioned, Lordship. Lordship, they filed their opposition, Lordship. We also.
Lordship, Mr. Harja is appearing virtually to mention. Lordship.
My lord, may I kindly request for this of a matter which is of great urgency. This was heard on 30th last month, and respondent has asked for taking some instruction, and it's kept in motion list. May I request for listing of this case in the next week? And if my lord will kindly, I would like to be there in person at the honorable before the honorable court on 29th, if my lords may kindly permit.
Maybe on new motion matter was appeared earlier circuit, but therefore
Much of it.
take right, but till then matter was not listed.
My lord, may I be permitted to mention one matter?
My lords, may I be permitted to mention a matter virtually, my lords?
Motion matter.
Later that I have mentioned Lordship, but it didn't come in the list. Lordship, kindly mention two motion matters.
My lord, may I be permitted to mention one matter? Am I audible, my lord? My lord, your lordship,
You are
mic is not
audible.
working. Yes, my lord. My lord, this is a my lord. Yes, my lord, this is a new motion matter, WPA 425, filed on 17th of March. My lord, on the first call, the state was not present. It's a new motion matter. So therefore, no representation from the state.
Please
Lord?
hand over the slip. Please hand
My
over
lord,
the
may I
slip.
be
Ask the
permitted-
junior to-
My lords, may I
Yes,
be
my lord,
permitted?
I will.
Yeah.
I will.
Yes.
My lords,
Yes.
my lords, may I be permitted to mention virtually? My lords, I had mentioned
Yes.
a matter, a land acquisition matter on Wednesday. My lords had allowed the mentioning. My lords may kindly list the matter. This matter is pertaining to the land acquisition done by the army of my tea gardens, my lords. I have in
It's motion or
1980
hearing stage. It's
My
at
lord, it
motion
was
or
a-
hearing stage.
My lords, it's on hearing stage, my lords.
Hearing, please wait, madam. Please wait. Yes. Call the list.
Much obliged, my lords.
In item number 1 to item number
24.
24, Food Corporation of India, the distribution lot. Hearing about my application for extension of interim order is there.
Yes.
Today I have been informed that Mr. Kundu would be giving the affidavit in opposition in all these matters.
All right. So you are
We
filing
will-
the affidavit
we
in
will-
opposition.
We will not file any reply.
You will
So it
not
can
file
be
any
straight away
reply.
Taken up for, if my lords permit me lords at 2 p.m. today, it can be taken up for adjudication.
Cannot be done. It's a hearing matter, Mr. Ashun. The affidavit in opposition.
My
You are filing
interim may kindly
today.
be extended. Yes.
You are filing today.
Yes.
Affidavit in opposition. Affidavit in opposition filed in court today is taken on record. Mr. Misro, what is this CAN 11 for? Is
For extension of interim.
CAN 11 no.
The interim order lords was last extended by
Yes.
way of a order dated 25th of March.
Till when it is continuing?
Lords, it was extended for 12 weeks,
Yes. So when
On
it will be
26th
expiring?
March 2026.
So it has expired.
It has expired on 17th June 2026.
After hearing the learned, after hearing the learned advocate for the petitioner and the respondent, and after going through the averments made in CAN 11 of after considering the ground stated in the application, stated in the application, this court is inclined to extend the interim order. The interim order is extended till
Till
the end
the
of the,
disposal of the writ petition.
is
This is the
extended.
11th.
You will be in difficulty if it is till the end. Is extended till the end of the month of November 2026 or until further orders, whichever is earlier. Full stop. Tarpore, can disposed of. Next, the application stands disposed of করে দিন না হলে অনেক কথা আছে তো তারপর WPA তে করে দিন the respondents and the affidavit in opposition filed by the learned advocate for the respondents.
Number
is-
4.
Respondent number 4
Only 4 is contesting.
is taken on record. Full stop. Petition will be at liberty to use an affidavit
No,
in
we will not.
reply,
We will state away.
if any, in the meantime. ঠিক আছে? All are same.
All are same.
All are same.
But probably in 3 of the cases, they will not be filing the.
শুধু ক্যান নাম্বার বলে দিয়ে দেবেন না বলার কি অ্যাপ্লিকেশন স্ট্যান্স ওনার অ্যাপ্লিকেশন নাম্বার দিতে হবে all these applications are extension applications.
Yes. But in 3 of them, I have been informed that he will not be filing the affidavit in opposition because he does not have the copy.
24 matters, except 3. 1, item number 1, 11, and below 18.
Yes, you will be filing or you will not be filing.
Not be filing.
One you will not be filing. ও তাহলে ওয়ানটাতে লিখবেন না one I have recorded you did not say anything.
18.
1, 11 and
18, item 18.
1, 11 and 18. 1, 11 and 18 টাতে কিছু হবে না মানে এফিডেভিটের ফাইলিং হচ্ছে না অন্যগুলোতে সব WPA নাম্বার করে এফিডেভিটস ফাইলড আর ওই যেটা
Can will be allowed, but affidavit.
can disposed of. Yes, next. Call 25.
Number 25.
Yes. Yes, who is appearing? Yes. What is this matter?
Typically, my lord, the petitioner is asking for compliance of the order passed by the Honorable High Court. My lord,
Yes.
page 55. The petitioner was working as a water fetcher under Dinhata 2 block development officer.
Yes.
Lordship kindly see page 29 of the writ petition.
Yes. There was a notice of hearing.
Yes, I have, my lord, sought for instruction whether the hearing was conducted or not.
25 hearing conducted. Now you have to conduct a fresh hearing, Mr.
My lord,
Bhattacharya.
possibly, my lord, a reasoned order has been passed. Whether it has been communicated or not, kindly keep it on Wednesday. I'll get instructions.
Yes, what is your instruction? This is not a pass.
Passover, my lord.
Why pass over?
My senior is addressing in court number 1.
Monday,
Wednesday.
Wednesday. The petitioner, the grievance of the petitioner is that in spite of a specific direction passed by a coordinate bench on 12th September 2023 in WPA 19803 of 2017, no decision on the representation of the petitioner has been communicated to the petitioner till date. First of Mr. Bhattacharya learned additional government pleader submits that that a hearing was conducted. First of he, however, seeks an accommodation to revert back with necessary instructions. Wednesday. For orders. Yes, next.
Item number 26.
Yes,
Yes, 26.
lordship. My humble submission is that affidavit of services is not complete.
You have served. Have you
Affidavit of
served?
ser- Yes, sir.
You have served.
Yes, sir.
They have received.
Yes, sir.
File it in course of these days. Yes, what is this matter?
The
File
matter-
the evidence service in
may
course
be
of this
kind
day.
to fix the matter in the next circuit.
On the prayer of the learned advocate for the petitioner submits that the copy of the writ petition is yet to be served upon the respondents. First up, petitioner is directed to serve a copy of this writ petition upon the respondents and file an affidavit of service on the next date on the prayer of the learned advocate for the petition. List this matter before the next circuit bench. Yes, next.
Item number 27.
27 years.
Statutory matter, but it has been wrongly inserted in the new motion matter. Lordship.
What is the problem?
It is allowed.
Yes,
My lord, if am I audible, my lord?
yes. Who is appearing for the state?
My lord, am I
My lord,
audible?
this is an
Yes,
overdraw.
Mr. Bhattacharya, anyone who can appear? All
My
right.
lord, this is an overdrawal on TR Challan matter, Lordship.
Overdrawal,
Overdrawal, Lordship.
which paragraph?
Lordship, paragraph number 6, Lordship. The amount has been deposited, it's one.
On 18th of January 2024. By one challan,
One challan, Lordship.
paragraph 6, overdrawal.
Lordship.
Overdrawal, paragraph 6.
6, Lordship.
Disposed of, next.
Stateful, Lordship. So there is a disconnect, Lordship.
Lordship in
Fixation,
She's not present.
fixation,
Fixation
একটা record করে দিন। Ms. Singh Lanet, junior government advocate submits that the petitioner has prayed for refixation of the salary. First up, the learned advocate appearing for the petitioner submits that the petitioner is not pressing his claim insofar as refixation of salary is concerned. এটা উপরে দিয়ে তারপরে এটা। Such submission of the learned advocate for the petitioner is placed on record.
My
Yes,
lord, am I
yes,
audible?
Mr. Majumdar.
My lord, I beg to be
Yes.
excused. I got held up before the honorable division bench in item number 1 to
Yes.
24. My lord, is the same, I say,
Yes.
identical matters. My lord, I represent the FCI.
Yes. Yes, so it has been extended till the end of the month of November.
My lord, I bow
And
down, my lord.
affidavits. Yes.
My lord, affidavits may be extended. My lord, kindly includes my presence. That's all.
Yes, yes. Please ask your junior to give your appearance.
My lord,
Who is assisting you?
My lord, I don't find any of my central councils here. I am requesting Mr.
Mr.
Rima
Majumdar
Sarkar to assist me.
FCR হয়ে, হ্যাঁ, act থেকে। All right, your presence is required. Yes, next.
In all the 24 matters.
Yes.
My lord, I appear from the private respondent. My lord, my junior, Mr. Mayank Bhandari, will be undertaking to file the wakalatnama.
Yes, yes.
My lord, the service is complete. my lord.
Service is complete,
My lord,
yes.
it's not taken on oath, my lord. I'll be submitting the activity of certain the course of the day, my lord.
All right. Yes, what is this matter? Who is appearing for the state?
It's a case of an overaction on the part of the police, my lord.
Overaction.
Yes.
Sometimes you are saying inaction, sometimes you are saying
Overaction, my lord. The house
Overaction.
was arrested, my lord, by the police under section 170 of BNSS. My lord. My lord, may I? My lord?
private respondent.
And state.
My lord, I represent the private respondent, my lord. Mr. Mayank Bhandari is before your lordship. He will undertake
Yes,
to
yes.
file the wakalatnama.
Yes.
My lord, there was a dispute between two brothers, my lord, with regard to the installation of an electric meter in the common space of a house, my lord. The house was gifted by the father to three brothers, and there was an this is a case.
What
my
do you
lord.
want? Declaration of the arrest?
Yes, my lord.
How can it be done in a writ
I'm
petition?
saying, my lord, it can be done, my lord. May I, my lord? May I, my lord? My lord, what has happened, my lord, with regard to this installation of the electricity meter? My
How
lord,
long you will argue?
it will take some time, my lord. My lord, the thing is that, my lord, at the common space,
Have you applied for bail?
it was 170, my lord, to prevent the cognizable offense in such petty case, a housewife, and a civil dispute, a housewife was arrested by the police, my lord. This is my grievance, my lord. How can they arrest me
My
from
lord,
my
in
house,
my,
my lord?
if
This
I
is
am
my
permitted, my
grievance.
lord.
Yeah. My lord, may
I
I
think, my
complete, my
lord,
lord,
the
thereafter you
state
can-
and both of us have to come back with an affidavit, otherwise this matter cannot be decided.
My lord, let me submit first, my lord, thereafter he can come with affidavit. My lord, the thing is that in the common space where the electricity meter was installed by the private respondent, but when this
What is the ground for declaration that the arrest is illegal?
because, my lord, as per
You are
section,
relying upon the Supreme Court judgment.
yes, my lord, I'm relying on
The Supreme Court judgment was passed on when?
It was passed in the year 2011. 2011. My lord. My lord, may I say a little bit, my lord, of the fact, my lord, then it
Let them file affidavits, let
My
them
lord,
come.
affidavit they will file only, my lord, but kindly, my lord, let me say, my lord.
This is a legal issue which has to be considered after affidavits.
Yes, my lord,
The
that is
maintainability
true.
also has
That
to
is
be
true, my lord.
considered.
That is true, my lord.
So there is no question of passing any interim order at this
No,
stage.
interim order, there is no question of passing any interim order, my lord. The affidavit is required to be exchanged, my lord.
Could have,
It's a very serious allegation against the police, my lord. How can they arrest when they themselves have stated in their application that this is a civil in nature dispute, my lord. And
Ashwin.
in order to prevent a cognizable offense, my lord, there is no
the
requirement. of
petitioner
arresting,
has
my lord.
paid for a declaration that the arrest made under section 107 BNSS and the proceeding arrest made is illegal and bad in law.
70.
You have said 107.
না আমি বলেছি 170 170
See your prayer. Prayer A. I'm going by your prayer.
then I think I vote
There's
170. It will be 170, madam. It will be 170.
There's a mistake.
Yes, there is a
একদম উপরে
My
লিখে
lord,
দিন
later
on the
amend
prayer
and
of
read.
Sarkar Lan- on the prayer of Ms. Sarkar, learned advocate for the petitioner, leave is granted to the learned advocate for the petitioner to correct the typographical error in the prayer portion of the writ petition, comma, here and now, full stop. Paragraph, the petitioner has prayed for declaration of arrest under section 170 BNSS as illegal and bad in law and has prayed for quashing of the entire proceedings. To stop, let affidavit in opposition be filed by the respondents within 2 weeks. 2 weeks, reply thereto if any. Within a week thereafter, parties will be at liberty to mention this matter for inclusion under the heading hearing after the expiry of the period is for exchange of affidavits.
My lord,
At a legal, there is no. Yes,
my lord,
Yes,
Mr.
Mr. Bojumdar.
Miss Sarkar mentioning a wrong section holds the court for so long. She should be penalized before the canteen.
That's between both of you. Acha, একটা করে দিন. Yes, maintainability you are raising, Miss.
Yes, my lord. Yes, my lord.
The learned advocate appearing for the respondents, learned advocates appearing for the state and the private respondent raises an objection as to the maintainability of this writ petition. ঠিক আছে, the issue of maintainability of this writ petition is kept open.
I'm grateful.
Yes.
Against the petitioner. We will demonstrate lordship by affidavit huge allegation against the petitioner lordship.
Yes, next.
Item number 29.
28.
I'm appealing on behalf of the
You are for the Shiliguri.
Item
Municipal
20.
Corporation. Yes, who's for the petition?
My lord, I am
Yes,
for the
who's for the
petitioner.
petition?
My lord, I am for the
Yes.
petitioner appearing online, my lord. My lord, I am
Yes,
humbly
yes,
paying
yes.
not today, my lord. I am humbly paying
What
not today, my lord. Kindly fix it on Monday.
No, not today business.
Yes,
Yes,
sir.
yes. No, not today business. Yes,
My lord-
please start. What is this matter?
My lord, actually, Mr.
What is this
Sopthamsu was
matter?
leading me in this matter. My lord, Sopthamsu was leading me in this matter. Kindly fix it on Monday. He will appear physically on Monday.
Ask him to appear virtually today. No Monday business.
My lord, my lord, kindly fix it on Monday because service is also not complete. My lord, I could not file the affidavit of service. Service is also not complete. Kindly fix it. I'm playing hardly 1 day
Then
adjournment.
I'm keeping it in the next circuit bench. If the service is not complete, I'm keeping it in the next circuit bench. You cannot complete the service within 1 day.
My lord, kindly fix
Yes.
kindly keep it on Monday, my lord. My lord.
On the prayer of the learned advocate for the petition list this matter on Monday. Municipality is the Siliguri Municipal Corporation is represented by its learned advocate. Yes, next.
Keep it.
Item number 30.
Yes.
Lordship, this petition is the SIR matter, your lordship.
SIR.
Yes, your lordship.
SIR.
For the spirit.
Disposed of. Next.
Item number 31 is also same lordship. Item number 30 to 35, your lordship, is the same matter.
30 to 35.
Yes,
All
yes,
SIR.
SIR lordship.
You are appearing, madam. 30 to 35 disposed of SIR.
And
Yes,
the
next.
lordship, item number 89 to 93.
89, please wait. Yes, call the next matter.
Lordship, kindly mention one line in the order, lordship. I will file the affidavit of service or affidavit of service in the commissioner room, your lordship.
Leave is granted to the leave is granted to the learned advocate on record of the petition to file the affidavit of service in course of this state. একটু দেখে নেবেন না ওই অর্ডার গুলোতে কি আছে
Within
ফাইল
lordship,
থাকে
can
তাহলে
I?
এটা লিভ এটাকে চেঞ্জ করে দেবেন
Lordship,
Yes.
within 3 months.
Yes, call the next matter.
Lordship, within 3 months. Within 3 months, lordship. Grateful, lordship.
Yes. Yes, call the next matter.
Item number 36. 35.
1 to 35 no, ভুল বললো বোধহয় 35 is not SIR 34 এটা ভুল হয়েছে 34 পর্যন্ত you said up to 35
My lord, 35 praying for one day accommodation, my lord.
No
My
one
lord,
day.
I am not the
Yes,
advocate
what
on
is this
record.
matter? What is 35? Please
My
give
lord,
me.
service is not yet been completed. I have served. It is yet to be effected.
What
There
is
a-
this matter? What is this?
My lord, regarding illegal construction.
Regarding illegal?
Construction, my lord. There is a
Yes.
separate read by the private respondent. My lord, I have also informed her, his advocate also.
You are for the
Appearing for 1 to 6 and 9.
1 to 6 and 9.
State maybe.
The learned advocate appearing for the petitioner submits that the private respondent is yet to be served. First up, petitioner is directed to serve a copy of this writ petition upon the private respondents and file an affidavit of service on the next day, Wednesday. Yes, next.
My lord, say in item my lord,
36, yes.
in item 36, I pay for 2 days. Service is not complete, my lord. I'll submit today itself.
What service? Service upon whom?
GP.
State.
Yes.
Yes, yes. Anyone from the state panel? Mr. Bhattacharya, please. Yes, move this matter.
Service is not complete, my lord.
State is here. Please move.
My lord, see, I am not the conducting advocate actually in
Say
the
so.
matter.
Who is the conducting advocate?
Ronit Kumar Jha. Ronit Kumar Jha, my lord.
Pastor, where is he?
Actually, due to some family matters, he could not come today. That's why he told me that he take that.
When do you want?
2 days ago, only Tuesday.
Then Wednesday. On the prayer of the learned advocate for the petitioner, please serve a copy upon the, Mr. Bhattacharya, please go through this matter and take instructions.
Grateful.
The learned advocate appearing for the petitioner submit. There is any private respondent?
No, my lord.
There is no private respondent.
No, my lord.
Your allegation is not against private respondents.
No, my lord.
Are you sure?
As
That your allegation
as
is not
as
against
per
private
the instruction
respondents.
of my AOR, there is no allegation against the private respondent. As per instruction.
Then how the writ is maintainable? Then how this writ is maintainable, sir?
Regarding police inaction, I suppose, my lord.
The petitioner, the learned advocate appearing for the petitioner submits that the copy of the writ petition has not been served, is yet to be served upon the respondents. First up, Mr. Bhattacharya, learned additional government period is present. First up, the petitioner, the learned advocate on record of the petitioner is directed to serve a copy of this writ petition upon Mr. Bhattacharya in course of this day, Wednesday.
Grateful, my lord.
Please take instructions, Mr. Bhattacharya, as to whether there is any cognizable offense or not disclosed in this complaint. Yes, next.
Item number 37.
Milord, we are,
Village will come, you are here. Yes.
Milord, we are challenging here, Milord, an order passed by the government, Milord, dissolving a municipality, and Milord, a subsequent order on the same date, appointing Milord the sub-divisional officer.
Municipality. So West Bengal Municipal Act
West
or
Bengal
the
Municipal Act.
corporation.
Municipal Act, West Bengal Municipal
West
Act.
Bengal Municipal Act.
In this matter, report is required, my lord.
Report? What report?
Regarding the appointment of administrator. They have challenged the.
Milord,
Let me see, yes.
Milord, I will show Milord, nothing
Bengal
further
Municipal-
is required on the materials which we have
Yes,
discussed, Milord,
yes,
it can be
Please start.
adjudicated.
Yes.
Now, Milord, kindly Milord, takes page 23.
Yes, 23.
Milord would kindly mark the date 30th June 2026.
Yes.
The additional chief secretary Milord is issuing an order stating, whereas the district magistrate Alipurduar Milord, I am placing this Milord, there is a purpose why I am placing Milord, certain words are very important. Whereas the district magistrate Alipurduar by memo number so-and-so dated so-and-so has sent the letter by memo number received from the executive officer Alipurduar municipality, and from which it has been learned that the chairman and vice chairman of Alipurduar municipality has submitted their resignation letters on so and so date, and no meeting of the board of councillors has been convened till date, as required under the provisions of the West Bengal Municipalities Procedure and Conduct of Business Rules 1995, resulting a stalemate situation in the municipal administration of the said municipality. And whereas resignation of the chairman and vice chairman of Alipurduar municipality may likely render the business of the said municipality non-functional, so far providing of civic services as per constitutional mandate are concerned. And whereas consequently the reported incident of resignation of the chairman and the vice chairman of the Alipurduar municipality as mentioned above will severely cause impact on normal functioning of the board of councillors following statutory method laid down in West Bengal Municipal Act, and to discharge the duties imposed upon it by or under the act and rules made thereunder or any law for the time being in force. Now therefore, in exercise of powers conferred by subsection 1 of section 431 of the West Bengal Municipal Act, the governor is pleased hereby to direct the board of councillors of Alipurduar municipality to show cause within 3 days from the date of issuance of this order, why it shall not be dissolved. Now, my lord, the order, this show cause proceeds, my lord, principally on the ground that, my lord, the chairman and the vice chairman has resigned, and the third paragraph, which forms the basis of the show cause, my lord, is a contemplation. Reported incident of resignation of the chairman and the vice chairman as mentioned above will severely cause impact. So on the basis of a contemplation, you issue a notice under section 431 of the act. Now, my lord, kindly I'll place page 24 onwards. Certain councillors in their individual capacity addressed the show cause. The board of councillors never preferred a show cause collectively. The councillors independently preferred a reply to the show cause. One reply, my lord, would find it is the same reply. Councillors have separately transmitted to the executive officer. And the show cause, the show cause, the reply to the show cause was within the stipulated period, but to the executive officer of the Alipurduar municipality. Now, let kindly see the contents of the reply. At page 24 is one of the replies. Acknowledgement of resignations. I acknowledge the situation arising out of the unexpected resignations of the chairman and vice chairman of the Alipurduar municipality, which has temporarily impacted administrative functions. Second, readiness for democratic resolution. As a responsible representative of the people, I am completely committed to preventing any long-term administrative stalemate. I am finally fully prepared and eager to participate in an urgent official meeting of the Board of Councillors to democratically elect a new chairperson and vice chairperson as per the provisions of the West Bengal Municipal Act. Public interest against dissolution. The dissolution of the entire Board of Councillors would severely disrupt ongoing civic amenities, public welfare schemes and essential development projects across all wards, heavily penalizing the citizens of so. I earnestly request to grant the Board of Councillors the immediate opportunity to convene a meeting and resolve this leadership vacancy internally, ensuring that the constitutional mandate and civic services remain uninterrupted. Now, what happens, my lord? This is submitted on, my lord, 3rd of July, within the stipulated time. On 3rd of July itself, my lord, turns over to 29. Page number 29. My lord, marks the date. Yes. 3rd of July itself, they passes an order. Now, therefore, page 30, in exercise of powers conferred by subsection 2 of section 431 of the West Bengal Municipal Act, the governor is pleased hereby to declare the Board of Councillors of the Alipurduar municipality to be incompetent to exercise the statutory functions imposed on it and to dissolve the Board of Councillors of the said municipality with immediate effect.
They have not made
Yes.
although we had made it.
Now, these replies which were made by the councillors, even though at their individual capacity, was not even considered, which my lord would find at page 29, the last but one paragraph.
And whereas neither any reply from the Board of Councillors of the said municipality nor from any councillor has been received by the department within the period specified in the state show cause order.
Yes.
Now Millard turns over to page 31. On the same date, 3rd July itself.
Yes.
The last paragraph. In exercise of powers conferred by subsection 3 of 431 of the said act for the purpose stated above, the governor is pleased hereby to appoint the subdivisional officer Alipurduar as the administrator of Alipurduar municipality with immediate effect.
Yes.
So, Millard, an elected board of councillor, which is elected in terms of section 243U of the constitution and read with the municipal act, is wiped out in a span of, Millard, 3 days. 30th July, show cause issued, and Millard, by 3rd July, it's gone. Now, Millard, kindly take section 431.
Yes, do you have a copy? Fill in.
In this case, the instruction is still awaited from the
Municipal Act. Mr. Ghosh, do you have a copy of the Municipal Act?
Yeah, municipal act of the other. Yeah,
আপনি পাঠিয়েছেন একটা 431.
431.
Yes.
Millard, kindly sees the marginal note first. Power of the state government to intervene in case of gross neglect or serious irregularity. If, in the opinion of the state government, the Board of Councillors has shown gross neglect in the performance of the duties imposed upon it by or under this act or any other law for the time being in force, or has committed serious irregularities in the performance of such duties, the state government may, by order, direct the Board of Councillors to show cause within the period specified in the order, why it shall not be dissolved on the ground of charges mentioned in this order. If the Board of Councillors fails to answer the charges within the period specified in the order or within such further time as may be allowed by the state government, or if the answers do not convince the state government, or where this is not applicable, Millard, the state government may dissolve the Board of Councillors by an order published in the official gazette with effect from the date of the order. Next, where an order of dissolution has been passed, all the powers and functions vested upon the municipal authorities under this act or any other law for the time being in force.
That is the consequence.
That is the consequence. Now, Millard, the basis.
So you are challenging the dissolution part.
I am challenging the dissolution and the subsequent appointment of the administrator naturally, because if the
If you do
dissolution
not
is
succeed
illegal,
on the first part, consequences
will follow. Now, the basis of exercising the power of dissolution, Millard, is demonstrated negligence and serious illegality. Now, Millard, in the instant case, what the show cause only discloses is resignation of the chairperson and the vice chairman, and the contemplation will impact delivery of civic amenities. So there is till date, on the basis of the show cause, or there is no independent finding or formation of the opinion, because the statute says in the opinion of the state government. So, Millard, this is a pattern which has been followed throughout the state. Almost all the municipalities, Millard, in the same manner, has been dissolved in this or that ground, invoking 431, and Millard, subsequently administrator has been appointed. And Millard, as we can understand naturally, this same action under section 431 in respect of Purulia and Jongipur municipality was challenged before this honorable court. Your lordships, a coordinate bench, 3 coordinate benches, Purulia, Jongipur, and another one, Millard. Probably this is Millard. ये कौन सा municipality का था? 3 municipalities, Millard. This court has outrightly, Millard, has set aside the dissolution as well as appointment of arbitrator.
Administrator.
Administrator, I'm sorry. এটা দিন। Oh. Milord would first take the first one which was considered by this court, that is Mysura Begum, WPA 486 of 2026.
Please give me a minute.
But para 14 onwards, Milord, Mysura Begum, I am placing for your lordship's
Please give
consideration.
me a minute.
Yes, Milord, I'm sorry.
Yes, Mr. Ghosh.
So, Milord, in Mysura Begum,
Mysura.
Mysura Begum, Milord, the power under 431 was exercised on the purported ground, Milord, that a mass petition has been received, that the municipality is not discharging its services. Now, Milord, kindly seize paragraph 14 onwards. What impressed the Honorable Court to, Milord, set aside the order of dissolution as well as appointment of the administrator. Para 14.
Yes.
As would appear from the above order, ordinarily the power under section 430 of the said act is exercised in case of default committed by the Board of Councillors. However, the power under section 431 of the said act is more drastic. In the instant case, since the state has initiated the proceedings directly under section 431 of the said act, this court has examined the said provision in detail. As is apparent from a plain reading of the provision, such a provision can be invoked only when the state government is of the opinion that the Board of Councillors have shown gross neglect in the performance of its duties as imposed upon it by the statute. However, to invoke such provision, Milord, this is where I lay emphasis, the state government has to, at the first instance, form a prima facie opinion that the Board of Councillors has shown gross neglect in performance of duties. It is the formation of such opinion of the state government which is a sine qua non for initiation of proceeding by issuance of show cause under section 431(1) of the said act. A perusal of the show cause dated so and so would, however, demonstrate that following the mass complaint as regards the disruption of municipal services, which have been identified therein, the above show cause was issued. The said show cause notice does not, however, identify formation of
Yes,
any
Mr.
prima
Mishra.
facie opinion.
No, do you want to take instructions and come back?
For all these orders that has been relied upon, all these orders are based upon mass petition. Here in this case is a little bit patient one. Second, in case of Mysore Bingham.
So if you want to come back with instructions, I can give you time. When can you come back? Monday. Come on Monday because Tuesday many matters have been fixed.
Tomorrow and day after is closed. So we will try, but.
This nowadays instructions is over telephone, you can take instructions, and Alipurduar is not very far.
I need to see that because this, I will explain. The resignation happened on 18th of June 2026. And
Yes.
the first order was issued on 30th June 2026. So it is evident that from 18th to 30th June, for 12 days, no meeting out, anything was done.
All right, you take instructions. I'm keeping it on Monday. Heard Mr. Ghosh, learned advocate for the petitioner. First up, Mr. Mishra, learned assistant additional advocate general, sixth and accommodation to revert back with necessary instructions. First up, list this matter on Monday under the same heading.
The ground here. Not much.
Let this appear at around on Monday.
Around?
Yeah.
If it is called on prior to that, you can.
38 hours.
Yes.
Item number 30.
Mr. Ghosh, only check up whether any appeal has been carried from this.
I will. That I will. No stay order has been granted, that I have confirmed.
This. Yes, Mr. Where is Mr. Mishra? You also check up whether, have you given the references?
Yes, I have supplied all the 3 copies I will.
Mr. Mishra, please also check up whether there is any stay order on. Yes.
Intra.
Yes, who is?
I am appearing on behalf of the petitioner in this matter. Your lordship, this is for intra-district general transfer on the ground of distance and surplus teacher. Your lordship, the representation is at page 25 of my petition, your lordship. Intra. So the chairman.
25.
25, your lordship.
DPSC is the answering.
Chairman DPSC being the
The
respondent number.
petitioner who is presently serving as an assistant teacher in a school within the jurisdiction of in the district of Jalpaiguri, 6 transfer. Where do you want? Transfer to?
Your lordship, he has given the name of 5 schools where there is a deficit
6
of.
transfer to these schools, the names of which has been specifically mentioned in the transfer application, situated within the district of Jalpaiguri.
Yes. 3 of
Situated,
them are within Moinaguri circle and 2 of them are under the Shodor East circle of Jalpaiguri DPSC.
within the district of Jalpaiguri. First up, the petitioner submitted an. How can it be considered now through physical mode? 30th of June portal started.
But they cannot apply, your lordship.
Why?
Because only Mehrun-Nisa, one school is showing for Jalpaiguri DPSC. It is not applicable, your lordship. For the secondary, the
The
application
petitioner
should be formed, your
submitted
lordship.
a
Yesterday I
representation
have checked, your lordship.
dated 6th of July 2026 before the chairman, Jalpaiguri District Primary School Council, Jalpaiguri, being the
Respondent number 7, your lordship.
7,
7, your
being the
lordship.
7th respondent. First up, heard the learned advocate for the DPSC and the board. Mr. Ghosh, you are for the board and the board. First up, paragraph without entering into the merits of the claim made by the petitioner in the representation dated 6th of July 2026, WPA number such and such stands disposed of by directing the chairman, District Primary School Council, Jalpaiguri, being the seventh respondent, to consider the representation dated 6th of July 2026 and to dispose of the same by passing a reasoned order, which shall be communicated to the reasoned order in accordance with law, which shall be communicated to the petitioner immediately thereafter. The entire exercise shall be completed as expeditiously as possible, but within a period of 4 weeks from the receipt of a
Give your blessings.
8.
Chairman has resigned now. Now PI is ex officio.
6 weeks. 6 weeks from the receipt of a server copy of this order together with a
Gratefully,
copy of the
Deeply
representation dated
obliged,
6th of July 2026.
Affidavit of service may be taken on record.
Yes, next. Every service taken. 39, yes.
My lord, I beg to appear for the petitioner, my lord.
Yes.
My lord, the matter relates to regularization of a group 3 staff in a state-aided school.
All right, not today. Next.
Lordship.
Next.
Item number 40.
40, yes. 40, who is appearing?
Milord, corridor briefs just now collected.
You are accustomed to that. You can get ready, Mr. Ghosh. All right, not today.
Instruction আসবে তো সোমবার Monday instruction আসবে তো
Yes, next. Why?
We'll have to take the instruction Monday. Only Tuesday.
What instructions?
It is a customs matter regarding release of.
An accommodation has been sought for by Mr. Ghosh, learned advocate for the petitioner. Full stop. The learned advocate appearing for the state also seeks an accommodation. You are for the customs. The learned advocate for the customs authority also seeks an accommodation. Full stop. List this matter on 29th. Yes, next.
Item number 41. I appear for the state trial of
Yes.
covering letter. It was scheduled to appear on 27th. In any case, I will need instructions because the petitioner has challenged the departmental proceeding order as well as the appellate, statutory appellate order. This possibly has to be on affidavit.
No, Milord, let us have it on Milord any day subject to Milord his convenience. I have no problem. Milord, hear it for 5 minutes, then whatever your lordship decides.
Affidavit has to be exchanged. my lord.
Yes, yes, Mr. Ghosh, what is the point you are urging?
Milord, we are only saying Milord, the SAT
You are
is,
challenging an appellate order.
yes, Milord, SAT is not functional. Admittedly, there was one administrative member. He has, Milord, I am retiring in December. Milord, there is some
You are
urgency.
retiring.
Yes.
Disciplinary proceedings, what is the punishment?
Milord, reduction in rank. So, Milord, kindly, Milord, hear me for 5 minutes on any day, Milord.
Yes, where is the appellate order?
Milord, I am not pressing it today. Milord, let him come back with instructions. Milord, on any day subject to his
Yes,
convenience.
but where is the appellate order?
Yes, Milord, I'll just
Page
place.
120 of the list.
120. Mr. Ghosh, you are challenging an order of June 2020 in 2026.
No, Milord, it is already, Milord, it was already challenged before the SAT, Milord, under compelling, sir. I will demonstrate, Milord. Allow me, Milord, 2
It
days.
was challenged before the SAT, then what happened?
Milord, allow me 2 days time, Milord. Let him come back with instructions, Milord. I'll just take 5 minutes of your lordship.
Yes.
But not today, Milord. I'm not placing today, Milord.
What is the point which you will be urging, Mr. Ghosh?
Milord, let me, Milord. I could
This
not.
is also a corridor brief.
No, not a corridor, Milord.
Mr. Ghosh, the scope,
Milord,
Article
I understand. Milord.
226,
I-
in a disciplinary proceedings matter is very limited.
But
Not very limited, very, very limited.
Milord, that's why I am
So,
also very reluctant.
What is the scope of interference here?
Milord, that is why I am also very reluctant, Milord. Kindly, Milord, take it up on Monday about Tuesday, subject to Milord his convenience whenever you want it.
On the joint
5
prayer
more
of the
take.
learned advocates for the respective parties, list this matter. On Tuesday, many matters have been fixed. Wednesday. Yes, next.
My lord, 42. My lord, I am 42. My lord, I am for the petitioner. My lord. Am I
Yes.
audible, my lord? My lord, this is the second round of litigation.
July, your lordship. We need some instructions.
27th
My lord,
of July, you
kindly,
have
kindly,
given
my
the-
lord, kindly, my lord, kindly hear
Certain
me for
letter, Mr. Roy is
everything
appealing
is
for
settled.
APSC.
My lord, everything is settled. My lord, I am covered by a division bench order. My lord, kindly hear me for 5 minutes, only 2
But you
minutes. my
have,
lord.
in the notice, maybe you may be covered by a division bench judgment, but in the notice you have mentioned 27th. The learned
27.
advocate appealing for the state. Yes,
My lord,
in
I
the
don't know.
communication letter.
My lord, that I don't
That's
know. My
the
lord,
learned
pardon.
advocate is so.
Yes, my lord, pardon me. my lord.
Then,
Pardon. Then pardon.
the learned advocate appealing for the petitioner submits that in the communication letter, it has been mentioned that the petition is supposed to appear on 27th of July 2026. To establish this matter on 29th of July 2026.
Oh,
But
Yes, next.
Mr. Roy is appealing for
The learned
APSC.
advocate for the state to revert back with necessary instructions. Yes, next.
Lordship.
Call the next matter.
My lords, for item number 43 and 44, my lords, just today morning I have been handed over the brief for this matter. Kindly
What is
take it.
this matter?
I am for the Union of India, lordship. This is 43.
We have also served yesterday evening. All right.
Tuesday, my lords, Tuesday.
On the prayer of the learned advocate for the petitioner, list this matter in the next week.
Tuesday,
Yes,
my lords.
next.
Great.
Yes, next. 45.
My lord, I am for the
Yes.
respondent.
I appear on behalf of the
Yes.
petitioner. my lord.
Lordship, I have got no instruction in this regards. Lordship, kindly give me.
Which item?
Lordship,
45.
45, I'm led by Mr. Anand. Lordship, for 45,
Kindly fix up on the phone,
petitioner
please.
led by Mr. Anand Banerjee.
Yes,
He's
yes.
virtually appearing.
Para 45
Yes,
is
but,
regarding the installments of payment provident fund which were granted, my lord.
Yes, what do?
Lordship, I have no instruction, but I informed that it is filing on the, yesterday I have informed that there are some
My lord, I am
instructions
only
given. Kindly
raised
fix
this,
up.
my lord, if
Which?
this matter can come up next week, my lord. In the meantime, let them not take any coercive measures without leave of court. Let it come up on
Lordship,
Monday.
Not,
Let
not
them
in the
not take any
meantime, Mr.
further coercive
Banerjee.
measures without leave.
No.
My lord, let them not take any coercive measures without the leave of the court. They have already
No,
attached.
what is the
my lord, they have already
coercive
attached
measure?
the movables.
What is the order
They
you
have
are challenging?
already, my lord, there was my lord, an installment facility of 72 installments granted. 72 installments have been granted to me for deferral, my lord, of the liability. I have already paid up to the second installment. The installment schedule is in vogue. Despite the same, my lord, by a current action, my lord, the movables, my lord, of the gardens have been attached by an attachment order, my lord, which has been made by the authorities and executed, my lord, on the 30th of June, my lord, 2026. Now, my lord,
So 30th of June, the order has been passed, Mr. Banerjee. You can wait for 1 or 2 days.
no, subsequent,
This matter.
only one prayer. Only one prayer, my lord. In the meantime, let them take no further coercive step, my lord. In the meantime, whenever, what is possible.
This matter
what is
on
possible,
Tuesday. Yes, on the prayer of the learned advocate for the state. Yes, next.
PA for the Lordship.
my lord,
On the learned
let
advocate
it
for the
retain its
Provident Fund
position.
Authority.
Let it
Yes.
let it
Yes,
retain its
I will
position in the
now.
list. Yes,
46.
oblige.
Lord, I am for the
Yes.
petitioner bank, my lord.
Yes.
My lord, if your lordship may kindly come to the list of dates and events, that much will be sufficient for this case.
What do you want?
I filed a petition, application under section 14 of the SARFACI before the district magistrate in the year
Who is
2024.
for the state? You are for the state.
You received any service?
You have not served.
I have served, my lord.
When?
I have served few days back, my lord, but it was served directly to the district magistrate.
You have served. But is there no system here? You have to also serve
No,
upon
my
the
lord,
government.
there was a confusion, my lord, as the state.
Oh,
of
yes,
West
I
Bengal
remember
was
my
not-
learned friend had called me yesterday. This is outside. I had asked him to have 2 copies served there. I have spoken to them. They will accept it. Kindly keeps it on Tuesday, my lord.
Yes, my lord. It is
What do you want? What do you want?
I just want the disposal of the section 14 application which was filed before the.
So what is this? I'm directing the
My lord,
disposal.
a copy may-
The primary grievance of the petitioner is that the application under section 14 of the SARFACI Act filed by the petitioner bank is yet to be disposed of. The learned advocate appearing for the petitioner submits that the application under section 14 of the 2002 Act was filed on
21/8/2024.
21/8/2024.
Yes, my lord, that is the.
On 21/8/2024. Full stop. Paragraph heard the learned additional government pleader on such submission, full stop, without entering into the merits of the claim made by the petitioner bank, WPA number such and such stands disposed of by directing the district magistrate Kuch Bihar to dispose of the application under section 14 of the Surface Sea Act filed by the petitioner bank as expeditiously as possible, but positively within a period of 6 weeks from the receipt of a server copy of this order, together with a copy of the photocopy of the application under section 14.
One indulgence, my lord, there is a statutory timeline of 30 days and which can be extended as an aggregate to 60 days only. And that too, we are writing the reason for the delay, my lord.
That will be decided there.
As a lordship.
Yes.
Much obliged. Get a copy.
Yes. In accordance with law. Yes, next.
I'm playing from short passover.
47.
I'm for the state, my lord.
Short passover.
Passover, yes, next.
Item number 48.
48, my lord. This is a gratuity matter, lordship. There's a
Yes, what is this?
lordship, it's matters pertaining to the interest on gratuity, lordship.
Yes.
It's revised under ROPA 2009 gratuity in area, lordship,
Yes.
but I don't have the server copy, lordship.
Why?
Corrected copy, lordship, because the yesterday's order are not uploaded at night.
Previous orders are there,
Lordship, I couldn't have lordship's
then
order.
not today. Yes, next. 49.
49 under revised PPO litigant same lordship. ROPA 2009.
Not today, next.
It's revised PPO under ROPA 2019. Here I have a corrected
Yes.
copy, lordship.
You are for the state?
Yes.
Yes, disposed of. Next. Call the next matter.
51 lordship, this is an overdrawn.
Overdrawal.
On TR lordship.
Overdrawal. Which paragraph?
Paragraph number 6 lordship.
Overdrawal.
6. Payment has been made in partly lordship in on 2 receipt lordship.
Paragraph number?
Number 6 lordship. First payment made on 3rd of March 2023. The second payment has been made in
Paragraph 6, overdrawal. Overdrawal এর একটা ফরম্যাট আছে। প্যারাগ্রাফ 6 এ বলা আছে কত টাকা কবে জমা দিয়েছে, দুটো তারিখ বলা আছে। ইন্টারেস্টটা হবে ফ্রম 26th of May, মানে লাস্ট ডেটটা থেকে। ইন্টারেস্ট হবে ফ্রম 26th of May 2026।
51.
লাস্ট যে ডেটটা আছে সেটা থেকে ইন্টারেস্ট হবে 26th of May 2026। Yes, who is for the state?
Both the learned advocates have called in sick, my lord.
Both,
Both.
anyone from the
They are there, my lord.
regularize করে দেবেন। Please give your
My
name.
lord, one humble request, let their names remain, my lord. She is there representing the state.
That's difficulty.
That's a
Mr.
difficulty.
Because,
Then regularize.
regularization. Because if they have not come,
Yes, yes, my lord, I understand.
yes, next.
52.
52.
I'm from the state, your lordship.
Yes,
Sir, single PPO only gratuity lordship.
Yes. Who is for the state? You are for the state.
Yes,
Yes, give your appearance. You have got the copy of the order.
I don't have the copy lordship.
Then tomorrow. Yes, next. Keep it with you. Yes, next. Not today. Next. 53.
Madam, I am for
53,
the
yes.
item number 53 for Employee State Insurance Corporation.
Yes. Yes. You are for the
Yes,
ESI,
Yes, my lord.
who is for the petitioner?
My lord, Mr.
None
Shoaib
appears for
Akhtar.
the- But he is
Mr.
not here.
Shoaib Akhtar is for, yes, my lord. I can assist this court,
None
my lord.
appears for the-
My lord.
None appears for the petition at the time of call. No accommodation has been sought for either. Mr. Mujumdar Learned Advocate appears for the Employees State Insurance Corporation Limited. Since the petition is not represented, WPA number presents us stands dismissed for default. Yes, next.
Problem.
54. 54, yes. Where is he? Where is he?
He's called sick, so he couldn't be able.
No, another advocate also appears for Shiliguri. Where is he?
Mr.
Engage in courtroom number.
Ask him to come.
My lord, I'm for the private respondent, my lord.
Yes,
I'm
yes.
for the my lord, everything is on record. My lord, I can assist.
All
my
right.
lord,
Yes.
in
I'm
this
for the
matter.
petition, Lordship.
Yes, what is this?
Lordship, the petitioner before your lordship is 90 years old. He is having a house in Shiliguri. The house is constructed in the year 1988. And now, on the basis of a complaint lodged by the private respondent, the Commissioner Shiliguri Municipal Corporation has passed an order to demolish the house because there is a road besides a private road, not a public road. The allegation is that it should be 11 feet. Now 3 feet has been encroached by the house. But the road belongs to the property of the petitioner, lordship. It's a private, not a public road. And there are
challenging that notice.
No, challenging that order, lordship.
What
Order,
is the order?
My lord, can you see the
order
demolition?
starts from page 69, lordship. The operating portion is page 71.
My lord, page 70 is important.
71.
Well, 70 is
71
important,
is the
my lord.
operating portion of the order.
70 says what are the violations, my
No,
lord.
no, this is part of a writ petition, page 70.
My lord,
770.
Yes. ঠিক file
My lord,
দিয়েছেন?
may I hand over one entire set, my lord? What has the commissioner done, my lord?
এটা কত নম্বর আইটে? 1099. হ্যাঁ।
1098.
इसमें रीड पिटीशन में पेजिनेशन
उल्टा पुल्टा दो साइड सर किया हम लोग को तो बोथ साइड पर पन्ना लाल
Pannalal Gupta.
भाई बोला फाइल गलत ना ना
Passover.
नहीं नहीं अभी फाइल ही
Passover, ask him. Yes, you have come. Passover, yes.
फाइल आ गया ठीक है
Right, my lord, Mr. Soroption is appearing on behalf of the
Well,
petitioner.
I appear for the petitioner.
Yes, Mr.
my
Sen.
lord. My lord, this in this
Why
petition, we
virtually,
have-
Mr. Sen? Why virtually?
my lord, then take it up on Wednesday. I can come down. my lord.
Yes, what is this matter? What is this
My
matter?
lord, we have challenged an order, my lord, passed under section 10(2), my lord, in this petition. Fact remains, my lord, initially an order passed by the sub-division officer Shiliguri, that is appearing at page 247, my lord. Thereafter, a notice under section 10(1) was passed at 251, my lord. Challenging the same, we have filed a petition, my lord, that is WPA number 588 of 2026. In that petition, an interim order was passed. My lord, just the interim order expired, my lord, a few days, my lord, they have issued a notice under section 10(2), my lord. My lord, we have challenged the 10(2) order in this petition. Subsequent filing of this petition, my lord.
Mr. Sen, there is, Mr. Sen, this is the 1964 Act. There is no provision to pass an order under section 10(4).
No, my lord. Fact remains, my lord, 10(1) order is under challenge, my lord. In that writ petition
No,
is
10(1), Mr. Sen, 10(1) is not an order. It's a notice of removal.
No. Based on an order passed, my lord, that order is at page 247, my lord. Based on that order,
247, please show me that.
247, my lord, order dated, my lord, 28th of January 2026. These order,
Yes.
my lord, this 247 and 251 both were challenged in a writ petition, my lord, WP 588 of 2026, my lord. In that petition, I have got an entry order that has been subsequently extended, my lord. No affidavits have been filed till date, my lord. And in the meantime, since the notice was given under 10.2, my lord, we have challenged in a separate petition. My humble prayer is, my lord, both the writ petition should be heard together, my lord. Because the initial writ petition along with the interim order is pending till date, my lord. My lord, that my lord will find the interim order, first interim order as 253, and my learned friend is present there, my lord. He will hand it over. But this order has been extended. 3-page order appearing at 253 has been extended to a subsequent order, my lord. That order is still there, my lord. I am wholly praying, my lord, that this writ petition be heard along with WPA number 588 of 2026.
Mr. Shane, you appear before the subdivisional officer because the only stage where a decision can be taken is a 10.3 stage, not any stage prior to that. That's the scope of section 10.1 and 10.2. So since 10.3, it has been referred to the subdivisional officer. Please appear before the subdivisional officer. Let him decide the matter on merits.
I am for the private respondent. The subdivisional officer, upon conducting inquiry, has already taken a decision that the encroachments are illegal. The decision is there.
Mr. Sen, if that is there, you have to prepare an appeal. Under 10.4.
No, my lord. That decision is under challenge, my lord. I have got an interim order in WPA number 588. That is appearing as 253.
You may have obtained an interim order, but that is not an order within the meaning of section 1964 Act. Because the scope of 1964 Act is initially 10.1 is a notice of removal. If that is not removed within a specified time, it will be referred under 10.2 to the subdivisional officer who will conduct a hearing under 10.3, then pass an order. So now Mr. Ghosh says 10.3 order has been passed. The remedy is appeal under 10.4.
No, my lord.
Alleging non-compliance of that order, a contempt proceeding has also been preferred against the subdivisional
order, my
officer.
lord. The order based 10.1 order was passed on a basis of an order.
Yes, where is that writ petition? Yes, where is the other writ petitions?
558.
588. It's appearing in the list.
No.
It's appearing in the list.
Direction for affidavits was passed. They did not file affidavit in spite of.
No affidavits are necessary, Mr. Sen. I will hear the writ petition, all the writ petitions together. There is no question of filing any affidavits on that.
Well, intentionally, this multiplicity
cannot be done. Mr. Sen, if you are if you intend to move that, I can tag all these writ petitions. I will be taking up for
kindly
do that.
There's no scope.
My lord's desire is so, my lord.
Challenge.
My lord, if my lord desires to do so, my lord, I have no harm. But the fact remains, my lord, in spite of repeated opportunities, they have not filed written affidavits.
Mr. Sen, you are well acquainted with the provisions of the 1964 Act. There is no scope of adjudication at any stage prior to 10.3.
That fact
That's
remains,
my
my lord,
reading of
order
that
has been passed
statute.
by the honorable court, my lord. They need to comply with the order, my lord. If that, and on the next
Mr.
petition,
Sen, Mr. Sen, even if that is so, that is under 10.1. That is under 10.1.
10.1, so far there was a
So you have
direction
not
by the
invited
honorable
the court. Mr. Sen, you have not invited the court with regard to the scope of 10.1. You have taken that.
10.1, my lord, there
What
was a
can be
series of
done now?
petition. There was
The
a series
private
of
respondent
petition,
does
my
not
lord. There was a
intend to file an opposition.
come
Well,
to a
kindly
clear
takes both the
finding
writ
whether I am
petitions.
in
Well, kindly
Yes.
hear it.
How many writ petitions are pending on this, Mr. Sen? How many writ petitions are
only one
pending?
is
Please give me the
pending.
numbers.
Our knowledge will have this and 588.
Yes, yes.
Or
No.
588 and this one.
WPA
588.
588
of
of
2026.
2026. Any other writ petition pending, Mr. Sen?
No, my lord. Only one. Only
So,
one.
right.
There is subsisting interim order also, my lord, in that writ petition.
All right. All
not
right.
to
Interim
proceed on
order.
the
If it is
the order
finally
pending.
disposed of. Yes. If it is finally disposed of, there is no question of extension of any interim order, Mr. Sen.
No, already I am enjoying interim order, my lord. Interim order has been extended on 9th of July.
So that will be till the final hearing. So I'm
Right.
taking it for final hearing on that date.
Yes, sufficiently enjoyed.
Then my lord is fixing the same on 29th.
29th is an auspicious day for you. I am fixing it on 29th. Please appear physically.
Nothing
Auspicious day, you said.
Wednesday is always good in the Bengali calendar.
Yes, that is why I have said that auspicious day for you as well as your client. You can come here physically. Weather is also good now.
No, whether I will be physically present or not, that will be considered. Because clients are all these.
No, you said that you will be coming on Wednesday physically. Your advocate on record is here.
I will try.
Yes. It has been submitted by Mr. Shane Larned, senior advocate, that that an earlier writ petition being WPA number 588 of 2026 is pending, and an interim order was passed in that writ petition. So after hearing the learned advocates for the respective parties and considering the issues involved in this writ petition, this court feels that WPA number 588 of 2026 should be heard along with this writ petition. To establish this writ petition along with WPA 588 of 2026 on July 29, 2026.
Only one indulgence, my lord. A copy of this writ petition may be served upon us in course of the day.
The learned advocate on record of the petitioner is directed to serve a copy of WPA 1099 of 2026 upon Mr. Ghosh, learned advocate for the private respondent in course of this day.
Yes,
The affidavit of service will be approved.
Every service taken on record. Yes, next.
I appear with my petition.
54.
54, yes.
Oh, 54. Sorry. This is a Passover item.
Yes, Passover item, yes. Yes.
Lordship, the petitioner is 90 years old, Lordship. He is the owner of this house. The house was built in the year 1988, and there was a sanction plan. And now in 2026, the commissioner has passed an order to demolish the building on the basis of a rule of 2006 and Municipal Act of 2006, Lordship.
What is the infirmity in this order? What is the
Lordship,
infirmity?
the commissioner says that there are shop rooms in the ground floor which are illegal, but there is a plan, sanction plan, which says the ground floor there are 2 shop rooms.
Please show me that this was placed.
Page 30 is the sanction building.
No. At the time of hearing, did you place the sanction plan? Please show me that.
Yes, Lordship.
Please show me that.
Kindly see para 3.
At page
69.
Para 3, yes.
During hearing of the opposite party produced a copy of the sanctioned building plan and also prayed for further measurement of the alleged building. There are twofold allegation. One is there is a.
Please give me a minute.
Initial plan was considered.
Yes, you have admitted that you have made unauthorized constructions at
Lordship,
the
the
hearing.
building was built in the year 1988, even before the corporation came into existence.
Maybe that does not authorize the illegal construction.
Lordship,
What can
90-year-old
be done?
man, how? If
What
the-
can be done? And you have admitted that.
No,
On the basis of that admission, yes, page 73rd paragraph. Eventually admitted to have erected unauthorized construction over and above the structure constructed beyond the sanction plan.
Lordship, that is their version, Lordship.
It's your version, opposite party. You have admitted.
He said neither denied nor disputed.
Then next sentence. He eventually admitted to have erected unauthorized construction. Initially you kept quiet, thereafter you admitted.
My lord, moreover, the plan which was passed in the year 1988 was also taken into consideration, my lord. Your
Yes,
lordship
what
will
can be
take
done?
that reference, my
Lordship,
lord.
90-year-old man, Lordship.
That cannot be a ground. That cannot be a ground.
And Lordship, the alleged road which is occupied by the house of the petitioner, it is private road. Road belongs to the house of the
That's
proper-
8 feet. Sanction plan says 11 feet.
Yes, Lordship.
Then it's a violation.
It's a private road, Lordship.
Maybe, but it shows 11 feet, now it's 8 feet. So it's also deviation from the sanction plan.
Lordship,
Yes. How is the complainant related? Yes.
My lord, I am
His
the
house
next door
is in
neighbor, my
the-
lord. I have 12 feet road, and where I leave my house, his house is there, and it is just 8 feet. So I cannot take my car in. It is inaccessible to us. Now his house is in the first house, and all the houses behind that, that is the second house is mine. I am unable to use my road, my parking, because the cars don't.
But this
fit.
house was constructed long back.
My lord, this has been constructed recently,
They are-
my lord.
they are-
have
Recently.
No, no,
yes, my
no.
lord.
They are-
88 plan, my lord. They are saying they constructed in 1980. The
1988
plan is 1988, my
No,
lord.
no.
They have
House was
kept
built
on
in
adding it, my
since
lord. Now my
1988,
main contention, my lord, my complaint was that 11-foot road is shown as per all
Their house
sanction
was
plans.
built
All
later
sanction
on.
plan is 11-foot road, my lord. I have left 12 foot. He has left 8 foot, my lord. That is
But
causing-
what can be done now? It's the on
my lord. Then
materials
already, my
which has
lord,
been found.
everything has been considered, my lord. They have
Cannot be-
wasted 1.5 years in this proceeding.
consider this. The deviations have been found. You have also admitted. What can be done?
90-year-old man, he will be homeless, Lordship. Kindly consider.
That you have taken that risk. Where is the West Bengal Municipal Corporation Act? You have the copy of the West Bengal Municipal Corporation Act. You have also changed the user of the ground floor.
It has become commercial, my lord.
Yes,
No, at the sanctioned building plan, it was shown as shop room.
partly residential, partly commercial. You have made it only commercial. How can it be? How can it be done? Sanction plan says partly commercial, partly residential, but now you have converted it to entire commercial. You have sold it out all tenant. What have you done?
No, sure.
Tenant.
It was under tenant.
Then everywhere violation.
You let them a fresh inspection.
No. Why fresh inspection?
3 inspection has been come.
Why fresh
conducted, my lord.
inspection?
My lord, I can show the, my lord,
No fresh inspection. Asun. This application under Article 226 of the Constitution of India is directed against an order dated is directed against an order of the Commissioner Siliguri Municipal Corporation dated 30th of June 2026. Full stop. By the said order, the Commissioner, Siliguri Municipal Corporation directed the petitioner to immediately seize the CAC, unauthorized commercial use of the ground floor of the subject premises. Full stop. The petitioner was also directed.
May I submit one thing?
Yes.
Worship, the ground floor commercial, we can correct that, Worship. We can.
Other portions, what you will do? Cantilevers and other things.
That's the building is demolished, Lordship. Kindly
Our
consider.
grievances
The
with
90-year-old
respect to
man,
the
he will be on
accessibility.
road, Lordship. Kindly consider that. The commercial purpose ground floor use, we will.
Yes, who is
rectify.
for the municipal
I'm
corporation?
happy.
Yes, where is your demolition sketch plan?
Demolition sketch plan is not there.
Then how can you decide which portion is unauthorized or where which to be demolished?
My lord, inspection report is there, my lord.
Where is the inspection report? Show me. Which
None.
portion is to be inspection report is one thing. You have said a certain
Sketch
construction.
map is not there, my lord. I bow down to your lordship, my
Then-
lord. I bow down to your lordship, my
Then
lord.
how can you demolish? How can you execute this order?
My lord,
Can you execute this order? Please prepare a demolition sketch plan. Then further hearing is to be given. Without the demolition sketch plan, how can you identify which portion to be demolished?
my lord, it's in regard to the width of the road, my lord.
Width of the road, sir.
No, there are also internal. There are
My lord,
also
if with- my lord,
internal.
may I
You have
submit-
not directed demolition of the entire building.
No, my lord.
Then,
My lord, may I
so
submit?
which portions are to be demolished? Where is there?
My lord, the portion, if the width is corrected, my lord, all the unauthorized portion will
Sir,
be
you are not
corrected.
you are not the technical expert. The corporation is there. Without a demolition sketch plan, how they can execute that? Can you today go and demolish?
No, my lord.
Then,
Sketch map is required, my lord. I
Then-
bow down. It's not there, it's a sketch map.
full stop. Paragraph. By the said order, the petitioner was also directed to dismantle or remove all the unauthorized portions which are contrary to the sanctioned plan dated 11/6/1988 within a certain time. Full stop. The order of demolition do not specify which portions are to be demolished. To stop on a query of the court, the learned advocate appearing for the Siliguri Municipal Corporation, in his usual fairness, submits that no demolition sketch map has been prepared, indicating the portions which are in violation of the sanctioned plan and should be demolished. Yes, now what do you want? You want this to be set aside to conduct afresh, or I have to stay this? Now the choice is yours.
My lord, may I just indicate, my lord, there is another proceeding, my lord, which is taken out by me for non-compliance of the order passed by the.
That has to go. That has to go, because they also cannot execute this order.
My lord, what, my lord?
Sir, you want execution.
I want execution.
So
of
can
this
it be
order.
done without
My lord,
identifying?
they can continue from after, my lord, 21st was given to the private opposite party to dismantle as per the plan. If he fails, thereafter
Cannot be done on a way. Yes, what do you say?
My lord, there is an inspection report.
Yes, please show me the
20th
inspection report.
20th of January 2026.
Yes.
My lord, late post 20th of January 2026, this order has been passed on 30th of June 2026.
Yes.
My lord, late.
Where is the inspection report?
That is at.
My lord, they have not annexed it, my lord.
Yes, where is that? Do you have a copy of that?
My lord, it was served to all the
Sorry,
parties.
my lord, I have marked it a bit.
That will
My lord, it is indicated in the order sheet.
This is
an inspection report.
demolition sketch plan.
No,
is
no,
not
this
there.
is not the sketch plan, my lord.
Then how can you demolish that?
Post 20th January, my lord, let any action taken by the Siliguri Municipal Corporation be set aside, and the sketch map be in the presence of both the parties after giving an hearing. Sketch map be produced and let.
You have to prepare a demolition sketch plan.
Yes, madam.
So I'm setting aside
Any
this
action post 20th January 2026.
20th January.
Yes, madam.
20th of January. So this order I'm setting aside.
Yes.
I'm directing you to conduct it afresh.
Afresh.
Afresh means demolition sketch plan and other things has to be made.
And let that be indicated, my lord.
Stop. Kiolo, on a query of the court, the learned advocate appearing for the Siliguri Municipal Corporation, in his usual fairness submits that no demolition sketch plan was prepared. So stop. Paragraph. The learned advocate appearing for the private respondent submits that an inspection was carried out upon notice to the petitioner and the private respondents, and the inspection report specifically speaks of the unauthorized construction. So stop. Be that as it may, without a demolition sketch plan, the exact portions which are to be demolished cannot be identified. So stop. For such reason, this court is inclined to interfere with the order impugned insofar as the yes, you have to restore that commercial part. Insofar as the direction passed by the Commissioner Siliguri Municipal Corporation in the order dated 30th of June 2026, directing demolition or dismantling of all unauthorized portions contrary to the sanctioned building plan dated 11th of June 1988 is concerned. So it is however made clear that the portion of the order directing the petitioner to cease the unauthorized commercial use of the ground floor of the subject premises and the default clause indicated therein are not interfered with by this court. So stop. Paragraph. Set aside ta bolechi ki? That portion of the order directing set aside bolechi is inclined to interfere bolechi. Accordingly, the order of the Commissioner Siliguri Municipal Corporation directing the petitioner to demolish / dismantle all unauthorized portions which are contrary to the sanctioned plan dated 11th of June 1988 within a specified time limit is set aside and quashed. Full stop. It is however made clear that this it is however it will be the Shiliguri Municipal Corporation is directed to proceed with regard to proceed afresh in accordance with law after preparation of a demolition sketch plan and furnishing a copy of the same to the respective parties.
My lord, yeah. Fresh hearing
Decision
has to be
stands
provided.
allowed in part.
My lord, a fresh hearing to both the parties has to
Has to be done.
My lord, kindly make it clear, my lord. Thanks, my lord.
Needless to mention that any decision taken by the municipal authority shall be after affording an opportunity of hearing to the respective parties and in accordance.
My
with
lord, may I take it?
this take.
My lord, I tender my apology, my lord, in attendance of
Yes.
Taking Passover matter. Passover matter, my matter got passed over.
That happens, busy advocates.
That here, my
Cannot
lord.
appear when the-
Circuit bench, my lord.
Yes, who is your other side?
We have served, my lord, in
But,
pursuant to your lordship's leave. We have served the office of the government today yesterday.
Yes, Kundul, you are appearing. Calcutta. Item number
Item number 47.
47.
Lordship, Mr. Mandal wants to mention something, lordship.
My lord, item number 29, my lord. My lord, passed an
29,
order.
yes, what happened?
29, it fixed on my lord Monday. My lord, kindly fix it on next circuit bench because my lord, one of the party is staying outside the jurisdiction. My lord. My learned advocate just informed me, so it will take some time. My lord, I'm humbly praying, my lord, kindly fix it in the next circuit.
29.
29, my lord. 29.
Item number
29.
Other side is also present.
Other side is also present.
Item number item 29 on the prayer of the learned advocate for the petition, list this matter before the next circuit bench. 29.
Deeply appreciated. Deeply appreciated.
Yes, 50. Where is your other side?
My side is there. I have just informed him.
All right, after this matter, yes.
47. My lord, I am for the ESI, my lord. In item number 53,
In
my
item
lord.
number 53.
Oh, 53.
My lord.
Yes, the learned advocate, he was engaged. So I'm restoring that. I'm
Yes, my lord.
keeping it on Monday.
No, my lord.
Yes, my lord,
It's
no
on
issues.
Thursday. The conducting advocate will be present here physically, my lord. He is from Calcutta, my lord.
What is the item number?
53, my lord.
53 ta na, on the prayer of the learned advocate for the petitioner, list this matter on 30th. kore din. Yes.
Obliged, lordship.
Yes.
I'm raising the point of independence.
You are for the state, and where is the bank?
My lord, yesterday we went to serve the bank. They refused. Flatly, they refused to accept. But it's very.
If without the bank, nothing can be done.
My lord, that I
Because
understand.
he is rightly raising the point of maintainability.
That
If the
yesterday only I.
But if in the absence of the bank, that order cannot be passed. If
Well,
they are
the
willing to
special-
accept the amount, it's settled, it's
My lord,
well and
the
good.
special-
Because at that time, none of you were there.
But the special officer, my lord, given us a notice saying that within 7 days, notice was given on 17th. Prior to that, our only contention is that I'm not about maintainability because law is very settled. Your lordship knows. Section 14, section 13(2). Well, there were acrimonious relationship with my husband. We were
What is the amount of due?
Well, amount of due. Now the bank says 6 lakhs rupees will regularize the loan amount. We are in a position, we are arranging because of the short period of time. We have only prayed for few days breathing time so that we can arrange. Otherwise, law will take its own course. We cannot.
But without the bank, this cannot be done.
And the special officer have served us a notice which is impugned.
Special officer.
Officer in pursuant to the order passed by Magistrate Darjeeling.
Where is that? Where is that?
Well,
order?
let your lordship kindly sees the special officer's order, which is at page 63 is the order, and it was 61 from which we have came to
63 special officer Devanjan Das.
Devanjan
Yes, where
Das.
is Devanjan Das? He was here.
He was here.
Where is Mr. Devanjan Das?
He refused to accept.
We cannot, he is not a party here. And only the thing is that we are praying, my lord, at least a fortnight, because we were not ever. My lord,
Difficulty with the, in the absence of the bank, I cannot extend the time. And the best thing which you can do is please approach the bank. Where is the bank?
We have
Please approach the bank, convince the bank.
We have approached the only for the timing, my
It's
lord.
the bank who will only execute this. Now, what you are saying here, I think it's better if you go to the bank. Where is the bank?
My lord, bank is my lord, at Shiliguri.
Yes.
We went there.
Please approach the branch at Shiliguri. I think that will be better. Yes, Mr. Das. Where are you? When you are going to take possession?
There is sudden development also. We got a communication that the police authorities went there, but could not find my learned friend yesterday. There was a communication which affidavit of service. I just say
Yes.
because
You have been
yesterday was
appointed as an advocate commissioner.
only appointed as a receiver, my lord. I do not have any further instructions.
Nah, you have to take possession. If my learned friend
I served a notice.
in pursuit.
I was instructed to serve a notice. Within 7 days, they have to.
That notice you have given.
Yes.
When will you be going to take possession?
There are a lot of formalities, Lord, because cost has to be submitted before the concerned police station. After the cost has been deposited, Lord, I'll be assigned a list of officers from there. Thereafter, the bank will fix a date. Thereafter, the bank's officers has to come from Bombay, Lord.
How long it will take?
I have to take instructions, Lord. In any ways, I am not representing ICICI Bank.
No, we knew that. It's not. As a
That I
special
know you are not representing ICICI Bank. You are the advocate commissioner. That is why I wanted to know when you are going to take possession.
The order was passed from the learned CGM long back. And Lord, they got ample time to vacate the flat. Thereafter, Lord, they did not vacate. Lord.
Our
I was
case-
instructed to issue a notice. That's all.
Well, that is
You
our
are
case,
getting
my lord.
time. Please
My lord,
go, I
yes,
think.
yes. As I understand from my learned friend, probably a fortnight's time will be there, my lord. Probably.
So I'm keeping it in the next week. I
My
think,
lord, next circuit. By
next
that time-
circuit.
next circuit, by that
but without any interim order.
My
I'll
lord,
tell you.
obviously, my lord, I cannot place for it. I cannot
Yes.
place for it. My lord, next circuit, in the meantime, my lord,
Or you can do, I'm keeping it in the next week. Do it in the meantime with the bank in the meantime.
in that event,
because-
my learned friend, my lord, say that he's not going to take at least 1 week within this week.
That is.
No, he cannot say, but it's
cannot
an,
say.
if it is a
That is why I'm keeping it on
next,
Wednesday.
my lord.
Please do it fast. Approach the bank. If the bank
My lord,
gets
my
the
lord,
money,
my
they
lord,
will not
it's-
take
my lord.
possession.
I cannot ask for more. I cannot ask for more.
For the present, I'm not recording your objection with regard to the maintenance. I'm keeping it on.
My lord, your lordship kindly fix it on 30th, Thursday. Thursday, your lordship would be there.
Thursday,
Your lordship would be there. And by this time,
Brihaspatibar bar bela.
but I
Might
cannot
be
have
difficult.
I cannot have a better case and a better judge than this, my lord. At the outset yesterday, I submitted, my lord.
On the after some argument, the learned advocate appealing for the petitioner prays for an accommodation to stop on the pair of the learned advocate for the petition. State is represented by the learned additional government leader. First of none appears for the bank. First up, in order to afford an opportunity to the bank to appear and contest, list this matter on 30th of July 2026. To stop the learned, the petitioner is directed to intimate the next date of hearing to the bank and file an affidavit of service on the meantime. In the meantime, on the returnable date. Yes, so service at that time you go and do whatever is needed.
Settlement is always welcome.
You are also welcoming that, Mr. Das.
He will be saved from a lot of trouble.
I have to suffer one day and go to take possession.
Taking physical possession, my lord, is a very difficult.
Whole days.
Yes, next.
Number 56.
My lords, I appear for the petitioner. Very short case, very short issue involved. Very small case. On the
praying for
records, my
time.
lords can decide this. On the records, my lords can decide.
She's praying for time. What can be done?
If my lords want, I cannot, I'll bow down. Very small issue, my lords.
Lordship, I need time.
If my lords want, I can place my case. Very small issue. I'll hardly take a few minutes.
But only difficulty.
This is an order of imposition of late fee and penalty for late filing of GSTR 9 and 9C returns. This is the order passed in the year 2023.
Registration cancelled.
No, not registration, my lords. This is Kali Prasad Rathi, my lords.
Yes, yes.
This is impugned order is imposition of penalty order, a late fee order.
Yes.
which is at page number 54.
The only thing is that in the order it has been recorded, it lists this in the next week, 23rd of July order.
Yesterday it was recorded, my junior informed.
Then your junior,
Very well. Very
she was also playing for
well. Tuesday, my lords, I'm requesting for Tuesday.
23rd, it has been fixed.
Very well.
Next week is, why, Monday will not be here?
Monday, I have some online, my lords, I have to appear. And if my lords will keep it, I'll try to.
Just Tuesday, many matters have been
Very
fixed.
well. I will.
Yes, next.
Both items, my lords. Oh, next item.
56, 57. দুটোতেই next week করা আছে?
Yes, ওখানে আছে.
All right. কিছু order record করতে হবে না? Yes, next.
Item number 58.
Please, allowed us to also pass over. Mr. Motion will appear for PF. Please on his next.
Who is appearing?
For PF of the
PA.
Please on his
You know,
next.
actually the dispute is regarding a payment of June 2012, my lord. As per the version of the petitioner, my lord, I have the bank statements that I made the contribution being an employer of 11,25,007 rupees 70 on 17th July 2012, my lord. But they are claiming by their statement that that payment was made on 22nd October 2013.
Where is that? Which page?
My lord. My lord, kindly come to page 18. That is my payment voucher.
18.
18, my lord. Page 8.
Yes.
11,25,000 rupees 70, my lord. Page 19 is
You
the
have
bank
paid on
statement.
14th of July 2012.
Yes, my lord. The check was issued on that date. And page 19, because check clearance takes time, my lord.
Yes.
Page 19, serial number 8, on 17th July 2012, 14,25,000 rupees 70 was debited through that check. And their statement, my lord, is at page 31.
31.
Page 31.
Yes.
Serial number 2, my lord, regarding page 31, serial number 2, regarding June 2012, they are showing the date of payment is 22nd October 2013.
22nd of October
2013. Now, my lord, I have the entire bank statements that on 22nd October 2013, no payment was made from any of my bank accounts.
Now, what has been done thereafter?
Now, my lord. Now, my lord, what has been done? I raised this to them. They impose as a penalty under damages under 14B and 7Q interest. They passed an order. Thereafter, my lord, from page 32, my lord, page 32. I sent them letters.
So you have sent the letter for
Reconsideration.
recalculation. What
Yes.
has been done?
They asked for documents. Page
Yes, then any
36,
decision
my lord.
has been taken.
I submitted documents, my bank statements, everything, but my representation has not considered yet. That is my prayer, my lord, that my representations kindly be considered because I have submitted all the documents as they claim. Page 39, my lord, documents which I have submitted, and page 38, they called for documents. Page 38 and 39, my lord.
Yes, where is the?
He's in his leg, lordship, in his next, before courtroom number 9. He's on his
For
next.
courtroom number 9.
Now regarding my lord, one submission may I submit? One submission, my lord, they may claim that this is an appealable order. 14 is an appealable order. They may claim, my lord. But after passing off that order, I submitted representations. They called for documents. I submitted documents. They initiated a proceeding, but now they are silent.
Where is their claim?
Their order, my lord.
Yes, their order.
My lord, page 24, 26.
24.
24 and 26. 24 regarding my lord 7Q interest and 26 is 40.
No, wherein they have said that
my lord,
you have not.
page 27.
Page
My lord, if this is a detailed order, my lord, there are other discrepancies, other delay payments. I have no objection to that. That can be considered by them. But regarding only my page 27, my lord.
Yes.
On 1/11/2023, department was directed to verify the payment of month of June 2012. Proceeding was adjourned 15/11/2023.
Yes.
15/11, hearing could not be conducted. Absence of authority, senior manager, so and so was present. Our party was present. 24th June, department was directed to verify the payment. After that, a letter White number so and so was sent to the employer of the establishment. Employer was directed to attend the last and final hearing on 29th August 2014. Department submitted that statement of penal damage and interest is system generated. All the account wise, month wise statements of penal damages and interest are leviable. So they are claiming that as it is system generated, we cannot do anything.
No, the case was reserved for orders. What happened after that? We are in the middle. Because June 2012, it was reserved for orders.
This is the entire proceedings. The order completes at page 30. They recorded the proceedings.
So we are agreed only by
Only
that
regarding
month.
June 2012.
And the others,
Others
you
I
are
have,
admitting
yes,
that.
Yes, yes, my lord. Others I have nothing. Because this is a huge payment of 11,25,000 penalty is very high regarding that. And I have bank documents, everything.
Yes, ask him to come. 12:55. Yes. Yes, call the next matter.
59. I'm led by Mr. Straff. He is in virtual mode.
My lord, I am here for the petitioner, my lord.
Yes.
My lord, the issue in this petition is already covered by your lordship, several judgments, my lord. The issue is that all the notices and orders were uploaded on the additional notices tab.
Mr. Saraf, this matter you were mentioning yesterday.
Yes, my lord.
You are apprehensive that it might not reach today.
No, yesterday I was apprehensive. Today it has fortunately reached. Which I was waiting for the whole week that it was not reaching actually.
Yes. Yes,
So
yes.
there is one more. So there is one more issue which I wish to canvass, even though my if your lordship considers that additional notices were issue, that would be sufficient for me. But in this case, one more issue is that the notice, there is a as per section 73 subsection 2, there must be a minimum time gap of 3 months between the issuance of the notice and passing of the order. So that time gap has also not been maintained. So that is the second issue, apart from the notice being put up on the additional tab. And in this regard also,
no, you are challenging the you are challenging the adjudication order or the appellate order?
My lord, both, my lord.
No, appellate authority, what did the appellate authority do?
My lord, appellate authority did not consider my continuation for delay. We had specifically canvassed that we could not file the appeal on time because we could not notice the order. It was as it was put up on the additional tab. That was not considered, and there is a judgment of this Honorable High Court S.K. Chakravarti, division bench judgment, that if there is a sufficient cause shown for condemnation of delay, then as per the Limitation Act, the time limit will apply and the delay should be condoned. And in this particular case, the justifiable cause for the delay is that all the notices and orders were put up on the additional tab. And there is another issue of the point of jurisdiction in passing of the order, that there should be a minimum time limit of 3 months between the notice and the order. And on that also, there is a judgment of Honorable Justice Kaushik Chanda that this 3 months time limit must be maintained. Otherwise, the order itself is liable to be quashed on that ground.
Yes, who is for the authority? Who is for the, you are appearing? Yes, madam, what do you say?
Microphone conference.
Lordship, it has to go.
Yes, what is the submission? Where is the show cause notice, Mr. Saraf?
My lord, the so-called
Summary to show cause notice, where is that?
My lord, that is on annexure P4, page 49, my lord.
Page 52.
Page 49 to 57. No, sorry,
49 to
SCN in DRC 01, 49. Forty-nine to 57. The so-called
49 to
notice is dated
57.
18/11/2024. 18/11/2024.
18/11/2024.
2024.
And the order was passed, adjudication order was passed.
The adjudication order is on page 32. Page 32, the order was passed on
32 or 37?
32,
32 or 37?
Page 32, 32. 32 to
Yes,
41.
Yes, the detailed order is at page 37.
Detailed order is page 37, my lord. The order is dated 27th of January 2025.
2025.
And where is the appellate order?
My lord, the appellate order is 26. But the order starts from
Where is the appellate order?
My lord, the page 27 onwards. My lord.
Page 27.
Yes, my lord. Dated, my lord, 27th of January 2026. Page 31, the date is stated, my lord. 27 January.
Mr. Saraf, please show me your ground for condonation before the appellate authority. Which paragraph?
I will show, my lord, page 145, my lord.
145.
Yes, my lord.
When you came to know about this?
My lord, I came
Order?
to know when my lord, the proceeding for, the recovery proceeding was initiated, my lord. Garnishee proceeding. Page 145, my lord.
Any
which is-
notice? 145.
Yes, my lord. Condonation of delay. Garnishee
Yes. The date of knowledge, have you stated anywhere?
Yes, my lord. In the petition we have stated.
Which paragraph?
I will just show. Page, my lord.
এটা দেবেন তো একটু GST Act.
Page, my lord, 8, 3.11. Paragraph 3.11.
30th of January.
30th of January.
30th of January.
Yes, my lord. 30th of January.
And 73(2) you are saying, where is that?
My lord, section 73(2), my lord, kindly refer to section 73(2). The proper official shall issue notice under subsection 1 at least 3 months prior to the time limit specified in subsection 10 for issuance of the order. So subsection 10 outlines, my lord, the limitation period for passing of the order, and subsection 2 says that at least 3 months prior to the passing of the order, the notice should be issued. But there is a judgment of this Honorable High Court, my lord.
Yes, where is that?
My lord, my junior will hand over.
Yes. In which matter, which page?
My lord, first page 1 itself. The original adjudication order dated so and so, dated February 2023, passed under 73 subsection 3, as well as the order of the appellate authority cannot be sustained. It appears that a so-called notice dated June 13, 23 was issued to the petitioner under 73(1), alleging short payment of tax, including tax not paid, short paid, erroneous refund of input tax. The adjudicating authority fixed February 13, 23 as the date for filing a reply as well as for personal hearing. However, the petitioner failed to appear on the said date. Thereafter, the adjudicating authority proceeded to pass the order on February 22, 23. It does not appear from the record that any further date of hearing was fixed. In my considered
No, what was the initial date here? What was the initial date of the show cause notice?
In my case?
Yes.
In my case, my lord, the date of show cause notice was 18th November 2024.
18th November. And
Yes,
the
ma'am.
order was passed on?
Order was passed on 27th of January 25. So the time limit is 77
3
days.
months.
But it is less than 3 months.
No, no.
Suppose notice is dated 18th 11. So the 3 months will expire on my lord 18/2.
Yes, an order was passed on?
Order was passed on 27th of January 25.
Yes, so
On
it's
eight-
after that.
No, prior to that, my lord. On 18th February 25, the 3 months will lapse. The order was passed on 27th January itself.
Oh, 27th of January.
Yes, my lord. 3 months
Oh,
is
I
over
was-
on 18th of February 25.
Yes, Ashwin.
Near 70.
The adjudication order dated
Adjudication order dated 27th of January 25.
dated 27th of January 2025 passed by the respondent number 2 under section 73 within bracket 9 of the WBGST/CGST Act 2017 and the appellate order dated 27th of March 2026 passed by the respondent number 1 are under challenge in this writ petition. Full stop. The a show cause notice under section 73 was dated 18/11/2024 was issued on the ground that upon scrutiny of the records, scrutiny of the returns furnished by the petitioner for the period from 1/4/2020 to 31/3/2021, judgment for certain 1/4/2020 to 31/3/2021, certain discrepancies were detected and detected, full stop. The an ex parte adjudication order under section 73 within bracket 9 of the WBGST/CGST Act 2017 dated 27th of January 2025 was passed, determining the liability on account of tax, interest and penalty as well. Tax, interest and penalty. Full stop. The petitioner alleges that the show cause notice, comma, the reminder letter, as well as the adjudication order were uploaded in the additional notices and orders tab, additional notices and order tab, and not in the normal tab, for which the petitioner could not submit the reply to the show cause notice within the specified time frame. First up, adjudication order notice or reminder letter. He further submits that the petitioner further alleges that since the date of personal hearing since the petitioner was not aware of the date fixed for personal hearing, was not aware of the date fixed for personal hearing, petitioner could not appear before the authority at the stage of adjudication. Full stop. Paragraph. The learned, Mr. Saraf, learned advocate appearing for the petitioner, submits that the petitioner came to know of the ex parte order of adjudication only after receipt of a letter dated 30th of January 2026 in connection with a recovery proceeding. First stop. Since there was a delay, the petitioner thereafter preferred an appeal along with an application praying for condonation of delay, as there was some delay in approaching the appellate authority. Full stop. Mr. Saraf submits that the petitioner was prevented by sufficient cause for not approaching the appellate authority within the specified time frame, and the appellate authority, without considering the grounds shown by the petitioner, dismissed the appeal as time barred. Paragraph. Mr. Saraf further submits that the order of adjudication was passed prior to expiry of 3 months from the date of issuance of the show cause notice. He thus submits that there has been violation of the provisions laid down under section 73 within bracket 2 of the WBGST Act 2017, and for such reason the adjudication order is also liable to be set aside and quashed. Full stop. Paragraph. the learned advocate appearing for the state seriously disputes the submission of Mr. Saraf. She submits that the petitioner cannot take the plea of ignorance as the notices and the adjudication order was duly uploaded in the web portal of the GST authorities, which is sufficient compliance of the provisions under the relevant statute. First paragraph, heard the learned advocates for the parties and peruse the materials placed. First up, it is not in dispute that the show cause notice and the adjudication order were uploaded in the additional notices and orders tab at the relevant point of time. First up, it is now judicially settled that uploading of notices and orders in the additional notices and orders tab cannot be said to be sufficient compliance, cannot be said to be sufficient communication as per the provisions of Section 73 of the WBGST/CGST Act. That apart from the reminder letter dated Mr. Saraf, where is the reminder letter? Reminder show cause notice. Please give me
Reminder
the
about the
page.
show cause notice, my lord. That is on paragraph 3.6, my lord.
No. Thereafter, a reminder letter was issued. Where is that page?
But page 5, my lord. We have stated, my lord, the reminder.
No,
letter.
not page 5.
Reminder letter for.
There is a reminder.
Page number 56.
Page
number 56.
56.
Yes, sir.
56 and 57.
That apart from the reminder letter dated 6th of January 2025, it appears that the date of personal hearing was fixed on a date prior to the date fixed for filing the reply to the show cause notice. First up, thus, there has been a violation of the principles of natural justice as adequate opportunity to defend the show cause notice cannot be said to have been afforded to the petitioner. First up, Section 73 within bracket 2 of the WBGST/CGST Act states that the proper officer shall issue the notice under subsection 1 at least 3 months No, Mr. Saraf, 73(2) carries some different meaning. Eta chhede din. 73(2) is not that. It's a different meaning.
73(2) says that there must be a time gap of 3 months, my lord. That is how, my lord.
No, that's not the reading of 73(2). If you want me, I can explain that. I'm not going to that. 73(2) ta kete din. Dusra paragraph. Thus, it is evident that in view of the fact that the show cause notice and the adjudication order was uploaded in the additional tab, this court is inclined to accept the contention of the petitioner that they were prevented by sufficient cause for not approaching the appellate authority within the stipulated time frame. Full stop. The appellate authority failed to appreciate the fact that the uploading failed to appreciate the undisputed fact that the notices and the adjudication order was uploaded in the additional tab and not in the normal tab. Full stop. For such reason, for all the reasons as aforesaid, this court is inclined to interfere with the adjudication order as well as the appellate order. Full stop. Accordingly, the order of adjudication dated 27th of January 2025 passed by the second respondent, and the appellate order dated 27th of March 2026 passed by the first respondent are set aside. Full stop. The petitioner shall be at liberty to submit reply to the show cause notice within 14 working days from the receipt of a server copy of this order. Full stop. The second respondent shall consider the reply to the show cause notice if filed by the petitioner within the time specified herein before, and shall decide the issues raised in the show cause notice afresh, strictly in accordance with law by passing a reasoned order after affording an opportunity of hearing to the petitioner or his authorized representative as expeditiously as possible.
My lord, there is a consequential there also, my lord. There is a recovery of 35,62,062 from my lord, the ledger, electronic liability ledger, my lord. And a fees amounting to 10,900. So that, my lord, needs to be recredited to my account, my lord.
Mr. Saraf, let it be decided. I can direct them to decide it afresh. So if that is done, thereafter that will be done. What is the difficulty?
No, my lord.
So if you want, I can as expeditiously, adjudication as expeditiously as possible, but positively within a period of 4 weeks from the submission of the reply to the show cause notice.
No, my lord, my difficulty is that under section 107, even if I approach for appeal, I need to pay only 10%, my lord, of the disputed amount. Here they have recovered much more than that.
Now, Mr. Saraf, let it be decided. Since it has been recovered now, I have interfered with that. You file your reply to the show cause notice, it will be decided.
My lord, at least, my lord, kindly give me the liberty to make an application for refund of the amount which has been recovered. Kindly give me that.
It will be, petitioner will be at liberty to approach the adjudicating authority for refund of the amount already recovered from the petitioner in the meantime.
Yes, my lord, and kindly give me, my lord, at least 3 weeks time for filing of the reply. 3 weeks, my lord. Instead of 14 days, 3 weeks.
Why?
My lord, because my lord, the company
14 days. Mr. Saraf, you are ready with that. You have got that. 14 days is enough. In all matters, I am giving 14 days.
Grateful, man. Grateful. No.
Adjudication টা পরের লাইনে সেই জন্য বললাম, সেই জন্য আগে বললে আর এটা কেটে পাই। Yes, next.
My lord, evidence service be kept with.
Every service file in code to reset. Please take back your compilation.
Good.
Item number 58.
Good.
Yes, you are appearing for the PF authority. There's only one thing with regard to 1 month. There is one discrepancy. He alleges, where is that page? Please.
My statement, my lord, at page
Please kindly come to page 18.
18.
Lordship. So this is the payment voucher. This is for the month of June.
Yes.
June 2012. This is the date. See, the payment voucher is 14th of July 2012. This is by check. So please turn over to the next page. That's the bank statement. That check number, it was cleared on 17th of July. Because bank clearance takes some time. 17th of July. Now please turn over to the order, your order, as page 27. Third paragraph on the top. On 1/11/2023, the department. Have you got that? Third paragraph on the top.
On
1/11/2023.
November.
Yes. Department was directed to verify the payment for the month of June 2012. That is that month. Proceeding was adjourned to such and such. Thereafter adjournment. Please take the paragraph, bigger paragraph. Whereas on 29/8/2024. You have seen that?
Sopon Kumar Banerjee.
Yes, Sopon Banerjee such and such stated that the statutory dues as shown in the statement of the belated payment for the month is not the payment of the establishment. See, Banerjee also stated that the statutory dues for the month of June 2012 has already been paid by the establishment on 17th of July 2012. Submitted copy of the payment challan along with the copy dated 12th of May 2023 in support of their payment. Banerjee also requested to waive the penalty damages such and such. The case was reserved for orders. So now only this is the dispute. They have filed an application for recalculation only with regard to June. Others they are not disputing.
Lordship.
So you verify that and decide that application.
Lordship. So Lordship, on the other hand, they have been they've been informed that that has been not been paid by them, paid by them. That has been some miscommunication will happen. I think we have paid the check. But so far, our department, I have instructed.
But where is that finding? Who has paid?
Lordship, sorry.
Who has paid? Because who will pay? Other than the establishment, who will pay?
Nothing, not been paid. That remain undue, still due. That has been our department.
Right. So one thing, they have made a representation for recalculation. You consider that and pass an order.
Lordship,
only with regard to that month. Others, he is not agitating.
Lordship, 1 point. Lordship. Just a few days ago, a notification come to the Department of Labor. There is a Shubida. There has been one scheme in respect of 14B.
Yes.
So there, if there been any dispute, they can prefer this.
That is settlement.
Settlement.
Settlement is one thing. Here he says he has paid. Settlement, if he wants to go for some waiver,
both ways. If he is paid, then
yes.
This scheme is not been applicable. But if he is not been paid, then he has to be paid a heavy amount. That can be come to this scheme.
Yes, what do you say? This settlement
regarding June 2012.
Sir, June 2012, it's one thing. Other months, there is also a settlement scheme.
For that regarding, we are ready to go for settlement.
You are ready to go for settlement.
Yes, for
then you approach under this scheme.
Yes,
and with regard to the June 12, I am directing you to reconsider.
Yes, my lord.
On its own merit.
My lord. This is the my lord's.
My lord.
Where is your application for recalculation?
My lord, from page.
My lord, one thing.
25th of July 2025 is the last one.
Yes. 25 November 2024, then 11 December 2024, then 26 April 2025. Several reminders were sent.
No, 25th of July. Last page 39.
39. I think not 30.
39 is
July.
last one.
Yes, this was also.
So I am directing because this you have said, Ashun. The petitioner,
Milord, one indulgence, Milord.
yes,
25th July is the submission of our documents. They asked for documents, Milord, previous page.
5th
38.
July is passed, you have submitted.
I submitted documents.
Alright, I'm recording that. No, this 5th July of 2026.
2025.
2025. 25 July 2025, I submitted the documents. They asked for documents on 4th July
All right.
2020.
The immediate grievance of the petitioner is that the respondent authorities have not considered the representations of the petitioner praying for recalculation of the amount due from the petitioner establishment. First of the learned advocate appearing for the petitioner draws the attention of the court to the payment voucher in respect of the month of June 2012, dated 14th of July 2012, appearing at page 18 of the writ petition, and the statement of accounts of Axis Bank annexed at page 19 of the writ petition in support of his contention that the amount for the month of June 2012 has already been paid by the petitioner company through check, which was cleared on 17th of July 2012. So the learned advocate appearing for the petitioner submits that in spite of several representations being made, the petitioner, the respondent authorities have not considered the representation of the petitioner for recalculation of the amount due. So the learned advocate appearing for the Provident Fund Authority submits that a scheme for amicable settlement of disputes relating to damages under section 14B of the 1962 Act, namely Vishwas 2026, VISHWAS 2026, inverted comma, has been launched. Has been launched, and it is always open to the petitioner to approach the authority for settlement under the said scheme. First of paragraph, faced with such situation, the learned advocate appearing for the petitioner submits that insofar as the payment for the month of June 2012 is concerned, the authorities may be directed to recalculate the amount, and for the other period, the petitioner shall take steps in accordance with the relevant scheme. So such submission of the learned advocate for the petitioner is placed on record. Without entering into the merits of the claim made by the petitioner in the representation dated 25th of July 2025, WPA number such and such stands disposed of by directing the who will consider Regional Provident Fund Commissioner by directing the Regional Provident Fund Commissioner -2 Regional Office Jalpaiguri Employees Provident Fund Organization being the second respondent to consider the representation of the petitioner dated 25th of July 2025 and dispose of the same by passing a reasoned order after affording an opportunity of hearing to the petitioner and communicate the reasoned order to the petitioner immediately thereafter. The entire exercise shall be completed as expeditiously as possible, but positively within a period of 4 weeks. 4 weeks from the receipt of a server copy of this order, together with a copy of the representation dated 25th of July 2025. It is however made clear that it will be open to the respondent authority to call upon the petitioner to produce all relevant materials and documents in support of their claim, and if such a requisition is made, the petitioner shall be obliged to comply with such request to enable the respondent number 2 to pass a reasoned order. Yes, what I was saying.
That is been.
Covered.
That is why I asked you
My
to
lord,
stop.
My
My lord,
lord,
affidavit of service.
Yes.
my lord,
Affidavit of service.
my lord,
Please
Union
take
of
it on
India is
record.
represented. Lordship, Union of India is represented.
Grateful, Lordship.
Respondent number one.
Union of India. Yes.
Lordship.
Mr. Mojumdar, a learned advocate, appears for the Union of India through virtual mode. Yes, next.
Grateful, Lordship.
Item number 84.
Petitioner Lordship, this is a 84,
SIR
my lord.
disposed of.
My lord, am I audible, my
85.
lord? Same lordship.
86.
Yes. Same lordship.
87. Disposed of. 88.
Same lordship.
Disposed of.
89.
Disposed of.
I am for the petitioner.
90.
And 89 to 93 lordship, I am for the
Disposed of. 94.
with the
Disposed of.
liberty the
My lord, in
Previous service.
93,
89 to 93 lordship.
89 to 93.
Yes, yes.
89 to 93, affidavit of service, liberty to file affidavit of service in
my
course of
lord,
this day.
my lord,
Yes,
may I,
disposed
my
of.
lord, may I be permitted, my lord?
Disposed of. Next.
My lord, in 92, 93 and 94, my lord.
Disposed of. Next.
My lord, am I audible?
95. Disposed of. Next.
FIR matter. 96
Lordship,
96.
92.
Disposed of.
My lord,
Yes.
am I audible, my lord?
87
My
SR matter.
87 SIR matter. Yes, yes, I have disposed of.
Yes. This is service matter.
Affidavit of service, please file.
Lordship,
Grateful.
Yes.
Lordship, if I am permitted, my lord.
Yes.
My lord, in 92, 93, 92, 93 and 94, I represent the passport authority, my lord.
Yes.
My presence
92,
may kindly
93,
be
94, Mr. Mojumdar, learned advocate, appears for the passport authority.
And my lord, only I was saying
Yes.
this because their epic card has been rejected, we could not process their passport.
No, that is the defined. They only want the appeals to be disposed of within a certain time. I have
Right,
not
madam.
said anything with regard to any other thing. Only
Yes,
I have
madam.
directed the tribunals to dispose of within a certain time.
এই লাঞ্চের পরেই কি
My lord, yes, may I make a one indulgence, my lord?
Yes.
My learned senior is mentioning a matter, my lord.
Yes, Ms. Mukherjee.
My lord, my lord,
Yes.
my lord, my item is, my lord, serial number 78. My lord, it has been appearing from Tuesday. I have appeared twice. And my lord, today I have learned that there is a resolution of the bar that requesting the court to rise at 3:30. So my lord, I'm praying if it can be taken up at 2:30. Because there is a demand, my
Where
lord.
is your other side?
Mr. is the learned advocate is appearing for the state.
Mr. Mishra was
My lord,
appearing.
I am just, I will inform him.
Please inform. Yes, call the list.
I'm grateful.
Order number 60.
Lordship, I am appearing on behalf of the petitioners.
Yes.
Lordship, the
Yes.
petitioners
Yes,
are
what-
the parents and the siblings of the deceased workman, Lordship. They have already preferred one claim case, right, 29 of 2021, which is still pending.
Claim under what provision?
22. Lordship.
Employees compensation.
Employees
Who is appearing for
compensation.
the? Yes, who is appearing for the respondent? Union of India.
I have Lordship
Yes,
already
who is
served
appearing?
upon the respondents, Lordship.
Yes, who is appearing for Union of India? When have you served? Where is the evidence service? Listen. Where is your application?
Lordship, kindly. Page number.
Ashun. The grievance of the petitioner is that the application filed by the petitioner for compensation.
Page number 18, Lordship. The application.
Page number 18.
18, 1-8.
1-8 is the order sheet. 18 or 12?
12 is the order sheet,
What?
Lord. 12 is the order sheet.
12 is the application.
Okay, Lordship.
When have you submitted the application? CC number 29 of 2021.
Lordship. 16, 12, 2020.
that the application for compensation filed by the petitioner on 16/11/2021 before the commissioner employs compensation is has not yet been disposed of. Paragraph. In spite of service, none appears for the respondents. Footstep paragraph. WPA number such and such stands disposed of by directing the learned commissioner employs compensation. North Bengal region at Jalpaiguri being the third respondent to dispose of the application for compensation being CC number 29 of 2021 filed by the petitioner on 16/11/2021 as expeditiously as possible without granting any unnecessary adjournments to either of the parties. Full stop. It is however made clear that this court has not entered into the merits of the claim made by the petitioner in the said application, and all points are left open to be decided by the said respondent. Full stop. Yes, next.
Order number 61.
I think number 61, Lordship, the conducting advocate, Mr. Bhaskar Roy Mahasaya, Lordship, due to his personal difficulty, he leave this court, Lordship. Kindly make it not, Lordship.
But on Tuesday then, if I may bring it up. On Tuesday, I appear for the private respondents.
I am for this day. Private respondent.
Yes, respondent numbers 7 and 8.
Yes, this is.
Lord, they've said many things in the writ petition. Ultimately, their prayer is that we have constructed a building without the sanction plan. I have the sanction plan with me, my lord. I'll show that to you.
Before whom they have made a complaint?
Before
Siliguri
the-
Corporation.
Yes, municipal corporation.
Where is that?
And the complaint is at
Page 103.
yes.
No, that is before the additional district master and district
No, my
land
lord,
reforms
the
officer.
impugned complaint is at page 98.
Page
98.
98. Yes.
90.
Yes, who is for the Siliguri Municipal Corporation?
Siliguri Municipal Corporation is absent at present.
No, there is no grievance at all. This building.
I'm
has-
directing them to dispose of this representation
No,
upon
that can-
giving an opportunity of hearing to the respective parties.
That can.
Ashun, the grievance of the petitioner is that the grievance na kore to, the petitioner has alleged that the private respondent have raised an unauthorized construction on where is the property?
The property is at
Which plot?
Lord, the LR plot is 4891.
On LR plot number 4891.
Lordship, I
Mr.
am
The
there.
petitioner
Lordship.
submitted.
I am there, Lordship.
Yes. You dispose of this representation after causing an inspection, hearing the parties? Yes.
Yes.
The petitioner lodged a complaint before the authorities of Siliguri Municipal Corporation by a letter dated 1st of September 2025. So the grievance of the petitioner is that the municipal authorities have not taken any steps in spite of a complaint lodged by the petitioner alleging illegal construction. So the learned advocate appearing for the private respondent submits that the private respondent has not made any unauthorized construction on the plot in question. So paragraph, Mr. Dhol, learned advocate, appears for the Siliguri Municipal Corporation. Full he submits that the complaint made by the petitioner shall be looked into by the municipal authority and steps in accordance with law shall be taken. Full paragraph, since an allegation of unauthorized construction is made, it is the duty of the respondent municipal authority to take steps in accordance with law. First paragraph, without entering into the merits of the claim made by the petitioner in the representation dated 1st of September 2025, WPA number such and such stands disposed of by directing the
Commissioner.
Commissioner, Siliguri Municipal Corporation being the second respondent, to consider the representation of the petitioner dated 1st of September 2025, and after causing inspection of the property in question, upon prior service of notice to the petitioner, the private respondent, and any other person who may be affected by such inspection, and to dispose of the said representation by passing a reasoned order after affording an opportunity of hearing to the petitioner, the private respondent, and any other person who may be affected by such decision or their authorized representative, and communicate the reasoned order to the respective parties immediately thereafter. So the entire exercise shall be completed by the said respondent as expeditiously as possible, but positively within a period of 6 weeks.
6 weeks.
6 weeks from the receipt of a server copy of this order together with the representation dated we did. Yes, call the expert.
Item number 62.
Item number 62, the service has not yet been affected.
For the private respondent.
Private respondent is here.
For the estates.
Yes, what is
Then
this matter?
kindly make it a short passable, Lordship.
So please be taken on Monday, sir.
May I submit one thing?
Yes.
In the POXO case, they have revealed the name of the victim.
So I'm praying for the time, sir. Please be taken up on Monday. I'm praying for the
They have
time. Please be
revealed the
taken
name
up
of the
on
victim.
Monday.
The copy I have received.
Yes, madam. Who is leading you?
Lordship, where is Mr. Joydeep Kanta Bhowmik, Lordship? He is in.
Where is he?
Number 63.
63, yes.
I'm for the petitioner, my lord.
Yes. Yes.
My lord, petitioner's case is, my lord, the respondent number 4, the Health Recruitment Board issued an advertisement for application for the post of homeopathic pharmacist, my lord. Page number 28.
Yes.
My lord, let it be noted, my lord, the SC seat was reserved at 34, my lord. My lord, SC on page number 28, 34. My lord, then the petitioner being fully eligible participated in this process and was called for interview. The interview call letter is on page number 33.
Yes.
My lord, he attended the interview.
Then what happened?
My lord, then what happened?
Yes.
After the process was completed, after the interview was done, after the entire selection process was completed, on February 23, after the conclusion of the process, the respondent number 4 issued another corrigendum. Another corrigendum reducing the seat of 34 SC to 32 plus 2 with PWD, SC PWD. So that revised corrigendum is on page 38. Well, they changed the rules of the game after the game has been completed. Then, my lord.
Yes. Now, what is the stage of the recruitment process?
My lord, recruitment process is completed, my lord. The 34 seats not filled because they didn't find candidate. 2 candidate to SCPWD is not there. 32 seats has been filled, 2 are lying vacant.
Yes. Now, what do you want? Now what is?
My lord, on
Yes.
the merit list of the process was published on 13 February 23. 32 candidates of SC was there. I am the 33rd candidate. Initially, if the corrigendum was there, I would have been selected. My lord.
Yes.
This is my case, my lord. Now, my lord, there is a litigation history to this effect. My lord, I came before this court before the honorable single bench on WPS 1742 of 23. On 2023, my lord, the order is at page number 58.
Yes.
My lord, in this, the honorable single judge held that the corrigendum was the revised corrigendum was absolutely improper and impermissible, as the rules of the game cannot be changed after the game has been started.
Yes. Then,
my lord, then the state preferred an appeal. The appeal order is at page number 62, my lord.
Yes.
My lord, in the appeal, the honorable division bench held that my lord, they were of the same view that the rules of the game cannot be changed, but the maintainability point was raised, and the same was referred to the tribunal. Sent back to the tribunal. Now, my lord, I go to the tribunal. The tribunal order is at page number 72.
Yes.
My lord, the tribunal by cryptic order dismissed the petitioner's application, terming the reduction of vacancy as a purely administrative decision. Then I again come back before this honorable court on WPST number 10 of 25.
Yes.
That the order is at page number 77. My lord, this honorable court ordered to set aside the previous order of the tribunal and remanded the matter for fresh consideration on merits on 4th September 2025. Now the tribunal is not functioning since 8th September 2025. I am left without a remedy. That's why I come before this honorable court.
Yes, what do you say?
We need to take some instruction regarding that, Your Lordship.
When can you come back?
Next week. Your Lordship.
Next week. The learned advocate appealing for the state seeks an accommodation to revert back with necessary instructions to stop list this matter. Next Wednesday?
If it is possible, then Thursday.
Thursday? Thursday.
Grateful, Your Lordship.
Yes, next.
Evidence of service.
Every service taken on record. Yes, next. 64.
I want the accommodation, Lordship, on the conducting advocate in the court number 9, Your Lordship.
What is this matter? You are the conducting advocate.
No, sure. I am not
Yes.
the brief, Lordship.
The issuing of death certificate, my lord.
Kindly, Your Lordship.
Issuing of death certificate.
Yes, they applied for one death certificate. The matter is in respect of that.
Yes. Now it's pending before whom?
It is
within 1 year.
it is beyond 1 year.
Beyond 1 year, then it has to be by the SDO.
Yes, my lord. And what I have
Pass it
one
over,
instruction from the
Kindly
lord.
pass it over, Lordship.
All right, pass over. Next.
I appear for the petition, my lord.
65.
65?
Yes.
My lord, this is a GST case.
Lordship, I am for the Union of India, Lordship, and CGST. Lordship, this is the appealable order, Lordship.
Yes.
There is
But
a
I have,
reason-
this is an inherent lack of jurisdiction. This is a case of inherent lack of jurisdiction.
Yes.
I will indicate without even getting into the brief. The show cause notice, my lords, I'll tell you the brief facts and back with the background. So, my lords, I am an individual mutual fund distributor. During the period July 17 to March 22, I was under a bona fide belief that no registration is required because there was an industry-wide confusion, and in the service tax era, there was no taxes on these services. So there was a confusion. DGGI initiated an investigation. DGGI is my lord knows, it's the intelligence wing. They summoned me. They told me that, are you willing to register and pay taxes? I said, yes, I am willing to do that. I will pay all the taxes. Within a week, they issued me a pre-show cause notice that was issued by the DGGI. Against that notice, I paid the tax amount. Penalty, I paid 15% because in section 74, there's a clause which says that if you pay interest, penalty, 15% interest and tax, then they don't need to proceed further with the proceedings. They can close that. Interest was not paid, so they issued me a show cause notice. Now, against that show cause notice, I paid the interest. And finally, the order was passed by the assistant commissioner. There, they have invoked triple penalty they invoked upon me, and which I will show that they cannot do. Now, first point, my lords, is on the point that the order had been passed by assistant commissioner. There is a circular by the board. The power has been vested to additional and joint commissioners and not assistant commissioner. Same issue came before Madras High Court and the case was quashed. This is a very recent judgment. That's point number one. Point number two, my lords, they have initiated a case of 74 against me. Now, I have myself paid all the taxes and everything. It should have been concluded under 73, my lords, in my most humble submission. That's a jurisdictional question which my lords can answer. Point number three is, my lords, they have clubbed 5 years in the show cause notice. Our High Court recently has decided this. There are different views taken by Delhi High Court, and there are several in my favor also. Considering all those judgments, now there is a reasoned order passed by our High Court, and my learned senior was only appearing there. On the last, maybe. And last point, my lords, with regards to multiple penalties. So, my lords, there is a section 7513 which says that once you have charged penalty under 73 or 74, you cannot levy penalty under the other provisions of the Act. They have invoked 122, two clauses they have invoked. Now, 122, even if they invoke that penalty, my lords, it says that penalty has to be either the amount of tax evaded or 10,000, whichever is higher. Now, my tax was paid already at the time of show cause. So even if they would have imposed that penalty, it could not have been more than 10,000. So that is my case, my lords.
The jurisdiction, please show me.
Yes.
Mr.
Yes.
Agarwal, what do you say with regard to the jurisdiction?
Yes.
That this assistant commissioner did not have the jurisdiction.
Yes.
If that is so, it has to go. You can take a fresh decision.
No, my lords, but
Have the jurisdiction.
Has the jurisdiction.
kindly see.
GST. Central GST. There is a circular. Who can?
No, central circulars I am showing.
Regarding the jurisdiction.
Yes, jurisdiction point. Kindly take, my lords, I have flagged it. Para 3A was inserted, my lords. Second page.
Yes.
Notwithstanding anything contained in para 3, notwithstanding, it starts with a notwithstanding clause. The additional commissioner or the joint commissioner of central tax, as the case may be, subordinate to the principal commissioners of central tax or the central commissioner or the commissioners of center tax as specified in column 2 of table 5 are hereby vested with the powers as specified with the corresponding entry in column 3 of the said table. Now, my lords will take table 5. Table 5 is the operative table. I have flagged for my lord's convenience.
Yes.
My lords will see page 2 internal. It's fifth large page, table 5.
Yes.
My lords will see the heading, powers of additional commissioner or joint commissioner of central tax for passing an order in decisions in respect of notices issued by the officers of the Directorate General of Goods and Service Tax Intelligence. There is a column in the power part, my lords, passing an order, next page. The second, I'm reading the second column, passing an order or decision in respect of notices issued by officers of DGGI under 67, 73, 74 is also there. And
You
these
are
are
on 74.
I am in 74, and in my case is that power the order has been passed by assistant commissioner, not the there is another circular, my lords, which was subsequent circular.
Power of the DGGI. The heading of schedule 5.
No. What?
Passing the order in respect of the office of the Director General, DGGI.
Yes.
Yes. Adjudication is done by the Extent Commissioner.
But the show cause is issued by DGGI.
Show cause is issued by DGGI.
That is my case.
That is his case.
Yes.
So if the show cause is issued by DGGI, so
How
whether
can you
it can be assistant commissioner.
Because the last the earlier occasion also, there is the power to the DGGI. To
There is another circular. Show cause
because he cannot dispute. Show cause can be issued by the DGGI, but the adjudication will be done by the Extent Commission.
Assistant.
These are the two provisions for the benefit of the SSC. It was incorporated. So I will place because so that's why I just say that adjudication power is not with the DGGI in the audit cases, but the so called they can issue. But in case of the centralized, like the more than 10 or 15 SSC, with the DGGI investigation, in that cases, they are also doing the adjudication, and this is not that case.
This is Madras High Court. Same issue. There is another circular I am also placing.
It is my lordship, give me the some time, because whatever the circular is placing, I will place the full things, because earlier I have dealt this case in another matter also.
Very well.
So I will place the.
When can you come back? When?
Monday.
My lords, there is also other points with regards to clubbing of show cause notices and other parts. That also they have to answer.
That will also.
Yes, yes.
Heard the learned advocate for the petitioner, first up, Mr. Agarwal, learned advocate appears for CGST. Appears for the Union of India and the CGST authorities. First up, he prays for an accommodation. List this matter Monday.
Tuesday. I have,
You have a
Tuesday,
problem?
Tuesday.
Then Wednesday.
Very
Yes,
well.
next.
Well, the affidavit of service may be kept on.
It will service taken on record. Call the next
Order
matter.
number 66.
66, my lord, I am for the petitioner.
Yes.
My lord, the petitioner, my lord, is a owner of a parcel of land adjoining to the, my lord, National Highway 27.
Yes.
Then, my lord, they own a restaurant come dhaba, my lord, on that property, on that parcel of land, my lord, since 2008.
Presence of national.
My lord, in around,
Yes, what are you challenging?
my lord, illegal construction by the private.
Encroachment
respondent
upon
in-
the land.
Yeah, National Highway land. my
Any
lord.
notice has been served?
No, not my land, my lord. The private respondents illegally encroached the land of National Highway and created a structure which is just in right front of my business.
Have you submitted a representation?
No, my lord, no, my lord. My lord, if this
Then-
I have made oral submissions, if this repetition may be treated as a representation and the authorities.
No,
can-
that cannot be done. Writ petition is addressed to the Chief Justice. How can an authority decide the writ petition as a
No, the-
representation?
My lord,
I give you liberty to
No notice of demand is there.
and under the National Highways Act, the district magistrate is the authority to decide. This is a recent circular of October. District magistrate has been vested with the
I was aware that the project director has.
project director initially. It has been vested now upon the district magistrate. The petitioner alleges that the private respondent has raised an construction by encroaching upon the portion of the national highway. Has raised a construction and is running a restaurant business by encroaching
No,
upon
my lord,
a
not restaurant
portion.
business. I am running the restaurant business, my lord. They are running a tire repair
Oh,
shop.
by
Tire
running
repair shop.
a tire repairing shop, tire and tube repairing shop by encroaching a portion of the national highway. First up, paragraph, on a query of the court, comma, the learned advocate appearing for the petitioner, comma, in his usual fairness, comma, submits that no representation has been submitted by the petitioner before the concerned authority for removal of encroachment from the national highway. First up, state is represented by the learned assistant additional advocate general. First up, Mr. Das, learned advocate, prays for liberty to the petitioners to submit a comprehensive representation before the concerned authority. First up, in the light of the submissions made by the learned advocate for the petitioner, WP number such and such stands disposed of by giving liberty to the petitioner to submit a representation before the concerned authority insofar as his grievance against encroachment made by the private respondents on the national highway is concerned. First of, if such representation is made, the concerned authority shall consider and dispose of the same in accordance with law after affording an opportunity of hearing to the petitioner, the private respondent, and any other person who may be affected by such decision. First up, the
A time frame, my lord.
yes, next.
Time frame, my
You have
lord.
not yet filed any representation. Why time frame?
I apologize. Grateful.
I have said expeditiously. Yes, next.
For the petitioner, a complaint has been made against illegal construction to the authorities that has not been considered. Madam.
Illegal construction
Yes.
by
by the private respondents.
Complaint made before
Before the authorities, my lord,
which authority?
my lord, the
Page
Panchayat
23,
Samiti,
page
page 24, my lord.
23,
The land belongs to DI fund, my lord, wherein the constructions have been made, my lord.
Land belongs to?
DI fund.
Darjeeling Improvement Fund land, my lord.
Yes, so this is under, who is the competent authority?
My lord, the Panchayat Samiti, my lord. My lord, the block development officer and ex-officer, officer of Panchayat Samiti, Matigara block development.
I will call an
Yes,
inquiry.
you are the private respondent.
Yes, my lord. My lord, kindly see in para 1, they are saying that I am in forceful occupation of DI fund land. I am representing respondent numbers 9 and 11. My lord, this land is having a history. This land was settled to me, to my predecessor in the British regime. My predecessor, namely one Jonglibin.
Yes.
Yes. During the British regime, this land, 256 kathas, was settled to me. And after the demise of Jonglibin,
Settled to you for what purpose?
my lord,
For what purpose?
Matigara, that is for heart
For
and
running a heart.
yes,
Lease,
yes,
it was
yes.
leased out.
Yes.
It is the windows.
Then
how
then
they
what
related-
happened?
And after demise of Jonglibin, 150 years back, the land was settled in favor of his wife, namely Dhanmaya Brahmani. Well, there is the there is the Khosra Khotiyan of the DI fund.
Yes.
After demise, Lordship, after that, my lord, that is a decree,
Yes.
my lord. Yes.
Yes, then
After demise of Dhanmaya Brahmani, a dispute cropped up between the DI fund authorities, the state of West Bengal, and the successors of Dhanmaya Brahmani. The successor of Dhanmaya Brahmani preferred a suit being OC suit number 57 of 1977. Yes.
yes.
Against the state of West Bengal as well as the DI fund authorities as well as 32 other persons. That suit was decreed with the order or judgment and order dated 4th day of December 1982, whereby the right title and
All right, then you file your affidavits.
yes, ma'am. Yes,
So this is
may I-
with regard to
may I-
illegal construction. Let them show
May-
whether they
may-
have
may-
in fact-
affidavits
My
to
lord,
file. Because he has a right, permanent injunction and other things are there.
My lord, kindly appreciate, this is not the case here.
Yes.
I have made a complaint with regard to illegal construction. What is showing is about the respondent number 9, my lord. And what about the other respondents?
Paragraph
No,
1.
what about the other respondents? He has not shown
I
that.
am for
And as on now,
respondent
there is no lease.
I am for.
Lease has
respondent number
expired
11
long
and
back.
14.
That will be
Yes.
considered.
No, lease has expired. This is with regard to illegal construction, not with regard to title of the
No,
property.
you have said forceful occupation.
I have made, kindly see my complaint, my lord. I have made a complaint for illegal, alleging illegal construction. Let that be inquired upon.
Please show
I
me
am
your
not challenging the
complaint.
title.
Please show me your complaint.
Kindly comes to page 24, my lord. I am not challenging the title.
What is paragraph
That-
1 you have
The
said? you have-
DI, District Improvement Fund is the owner of the land.
Now then,
District Improvement Fund is the owner of the land. The state will support that, my lord.
Yes, what is your instruction?
my instruction is that, my lord, on 20th of, I have a soft copy, my lord, 20th of July, the additional district magistrate Darjeeling has asked the block development officer Matigara to cause an inquiry with regard to the complaint made by the petitioner in respect of the nature of the construction, authorized or unauthorized.
Yes.
That is, my lord, going on. As per, my lord, section 114A, subsection 5 of the West Bengal Panchayat Act, the correctness of the construction, my lord, can be inquired into by the block development officer. If that is done, then there is a scope
Alright,
of.
so I'm directing you to consider that and after giving an
Notices to be given to everybody.
in terms of chapter 4 of the West Bengal Panchayat Gram Panchayat Administration Rules 2004 as well as chapter 12 of the West Bengal Panchayat Samiti Administration Rules 2008 because those prescribe the parameters.
Yes.
Yes.
As per law, it will be done, my lord.
As per law, that
After
will be done.
after giving notice to all the
The
parties.
petitioner alleges that the private respondent have raised unauthorized construction upon the DI fund land, Darjeeling Improvement, within bracket DI, fund land in the Matigara Hut area. Full stop. Mr. Paul, learned advocate appearing for the petitioner submits that in spite of the fact that the petitioner has lodged the complaint by a letter dated 30th of June 2026 before various authorities, including the block development officer, no effective steps have been taken by such authority till date. To stop paragraph, the learned advocate appearing for the private respondent submits that they are in lawful occupation of the DI fund land. Full stop, he submits that the construction made by the petitioner are in accordance with law and no unauthorized construction has been made by the private respondent on Matigara Hut in Matigara Hut area. Full stop, Mr. Bhattacharya
Having done this, Manoj, because that dwelling unit is standing there for 4 generations. Right now, it won't be possible for us to produce the.
Yes. But that is the here.
That's the authority will consider. And Mr. Bhattacharya, learned additional government pleader submits that who has instructed the video?
The additional district magistrate.
The additional district magistrate has requested the block development officer and executive officer of the Panchayat Samiti Matigara development block to cause an inquiry into the alleged construction made by the private respondent and to submit a report before the ADM.
Before the ADM.
And to submit a report before the ADM. To sub paragraph, since a complaint regarding unauthorized construction upon the Darjeeling Improvement Fund land has been made from this court is of the considered view that the authority should take steps in accordance with law. Full stop. Without entering into the merits of the claim made by the petitioner in the representation dated 30th of June 2026, WPA number such and such stands disposed of by directing the block development officer and executive officer Panchayat Samiti Matigara development block being the
Respondent number 5.
It would be the 7th respondent.
Being the 7th.
Wrongly mentioned the 6th one.
No, 6. 7 is Pradhan.
There are two. There is a repetition. Numbering is wrong. There is a repetition.
Then you have to
kindly
do one thing. 5 you make 5A. Then no. What is?
No, it's 6, my lord. There are two twos. There are two twos.
There are 2 twos.
So let it remain 6, my lord.
Yes,
As per
do 1, 2A. Then it will remain same.
Having done this, Manoj, kindly record that the competent authority, the ex officio executive officer, may ascertain whether the building has been constructed in compliance with the parameters and laid down.
Yes, in accordance with law, it will be done.
Being the respondent number 6, hearing to being the respondent number 6 to cause an inspection of the disputed plot and to decide the issue raised in the representation dated 30th of June 2026 by passing a reasoned order after affording an opportunity of hearing to the petitioner, the private respondents and any other person who may be affected by such decision or their authorized representative and communicate the reasoned order to the respective parties immediately thereafter. Most of the entire exercise shall be completed by the said respondent as expeditiously as possible, but positively within a period of 6 weeks on the receipt of a server copy of this order together with a copy of the representation dated 30th of June 2026. Full stop. It is however made clear that it be open to the petitioner and the private respondents to produce relevant materials in support of their respective claims and counter claims at the time of hearing, and the said respondent shall consider the same while passing the
to ascertain whether the parameters
that is in accordance with law. Has to be in accordance with law. Yes, next.
All parameters.
Grateful. I'm going to correction. Leave may be given.
Please, I've already reached the
Leave may be granted to correct the
on the prayer of the learned advocate for the petitioner, leave is granted to the learned advocate on record of the petitioner to correct the post title of the instant writ petition, here and now. Full stop.
Grateful.
Yes.
I'm appealing for
Yes, yes, what is this?
The petitioner's bank account has been freezed by the.
Leave to grant
Petitioner is a
virtually, my lord. I am appealing for
businessman
respondent 2 and 3.
He has a business of furniture and several, your lordship knows several.
Why it has been freezed?
Lordship, the bank has given a communication that.
Mr. Das, you are appearing for whom?
I am appealing for a bank, HDFC Bank, respondent 2 and 3, my lord.
Yes, what do you say? Why it was freezed?
Page
It
54
was
is
freezed
there.
on 2 grounds, my lord.
Yes.
It has been freezed on 2 grounds. There are 5 notices from different police stations around the country who has instructed us to freeze the account. The other ground is that, my lord.
Lordship, there is no transaction from my account. I have received money from one account.
It's difficult.
Let me finish.
Let a report in the form of an affidavit.
Lordship, may I submit one thing? Lordship, your lordship knows Supreme Court has passed the amount which is involved, that can be freezed. Other amount can be released.
Let them file a
No,
report thereafter.
This is not
As
the
per their
only issue. The
verbal
other,
communication, only 7,000 is involved.
there is other
And
issue.
my-
Yes, Mr. Das, what do you say?
There is another issue.
he said-
I am aware of the judgment of Supreme Court as well as our Calcutta High Court. But there is another issue is that there is a enhanced due diligence where we have requested the customer, meaning thereby the petitioner, apprise us the what kind of transaction it was. And he has categorically
Let a report in the
mentioned
form of an
that he is
affidavit.
not aware of such transaction and it was done by his son. And we have
All right.
sent them
The-
a notice.
Considering the nature of the, considering the issues involved in this writ petition, this court feels that the respondent should be afforded an opportunity to file a report in the form of an affidavit. So, sir, let report in the form of an affidavit be filed by the respondent numbers 2, 3, 2 and 3 within 2 weeks.
I don't, it can be 3 weeks because I have to draft it and send it back to them. 3 weeks.
Within a period of 3 weeks from date, to some
I'm
exceptions thereto, comma, if any be filed within 1 week. 1 week thereafter, Pusta petitioner will be at liberty to mention this matter for inclusion after expiry of the period fixed for filing of the report and the exceptions there. Yes, next.
Lordship,
Union also present, union.
Yes, union of,
Lordship, can it be motion, Lordship?
all right, adjourn motion. Go to the,
And Lordship, in the meantime,
in the meantime, what remains then in the writ petition? Yes, next.
Offline.
Item
69.
My lord, item 69,
Evidence
my lord, I
services.
beg to appear virtually, my lord. Item 69 and beg to appear virtually. This is, my lord, registration cancellation for non-filing of returns and covered by your lordship order, my lord. I am requesting learned advocate on record
Non-filing of
to hand over copy your lordship.
Yes, Mr. Boni, what do you say?
It can be allowed with the
Yes.
filing of the
Yes, yes.
together with penalty also.
Mr. Ovilas is requested to hand over copy order of Dipen Sharma, pencil mark copy.
Yes, by which order?
My lord, I am handing
Order
over,
of? No, when it was cancelled.
my lord, page 29, my lord. Order at page 29, so-called notice as page 24.
24th of May.
May 2024.
Order cancellation is 24th of May.
Yes, my lord. Yes, yes.
Order of cancel.
Yes, why have you mentioned 29th of May, madam? It's 24th of May.
Yes, yes. Page 29.
Then still you have, please correct this. You have said 29th. Diye din order. Yes, I'm passing this order.
Yes.
Yes, so এটা কে ওই যা আছে করে দেবেন correction.
I'm grateful. my lord.
Similar order আছে. Yes, next. 70.
My lord, item
70, yes.
70, my lord, I am for the petitioner, I am appearing online, my lord.
Yes.
My lord, the matter relates to, my lord, the petitioner is a professor, director of the Human Resource Center, my lord, now UGC Malavia Teaching Training Center. My lord, this institute imparts training to the teachers of the university and colleges. My lord, I am the director, I am in charge of the institute, my lord. My lord, there are
Who is appealing for the state?
Thank you.
So, yes. Have you served the university?
Yes, Your Lordship, I'm appearing on behalf of the North Bengal University, Your Lordship. The register has been appointed last week only, Your Lordship. Kindly fix this matter on Monday. By that time, I would bring
All
the-
right, on the prayer
Monday,
of the learned
my
advocate
lord,
for the
kindly
university-
Tuesday. My lord, Tuesday, kindly fix.
On the prayer of the learned advocate for the university, list this matter on Wednesday. Yes,
My lord,
next.
grateful.
All right.
Another 71.
Lordship, in this matter, by virtually I am appearing for the petitioner. My fellow brother is in court.
Yes.
Lordship, I humbly pray because the notice is served upon the respondent to move the matter on and after 29th, so 29th of this month. So Lordship, may kindly adjourn the matter till 29th.
On the prayer of the learned advocate for the petitioner, list this matter on 29th. Next.
Deeply obliged.
72.
Mr. Mullik is in the court.
Yes, yes.
Hello. Petitioner teacher, but he practically headmaster on 5th July.
Yes, what do you want?
Pay fixation.
Yes, yes.
Pay fixation.
Pay
Page number
fixation.
29. Page number 29, madam. My recommendation.
Page 29.
Yes, madam.
Yes, who is for the state? Yes, madam,
Yes,
what is
Your
the
Lordship.
instruction?
Actually, Your Lordship, as per my instruction, Your Lordship, this is lying for the consideration of the commissioner, Your Lordship. This is for the this is pending at the end of the commissioner, Your Lordship. Because,
Commissioner?
Yes, Your Lordship. As per my instruction, it is pending for consideration of the commissioner.
Then what do you want?
The same was forwarded on 5th March 2020 for taking necessary action by memo number 539, Your Lordship, as per the instruction given by the District Inspector of School, Jalpaiguri, Your Lordship. So,
Then what is your prayer now?
as I have been informed that the Commissioner of School Education, West Bengal, they have a separate panel, Your Lordship. But I am not. I do not know who really appears for them, but they have a separate panel. So this is pending at the end of the commissioner.
Then what can be done?
The commissioner will be directed
To dispose of?
to dispose of.
Where is your representation?
No, this is the
Which page?
That is representation.
My lord, the case is pending
Yes.
since 2020 for more than 6 years. And I
So
am
they are
suffering
saying
huge
that it is pending.
Yes,
It is
6
pending
years.
before the commissioner. So I am
Yes.
directing the commissioner to pass her order. Yes, where is your representation?
This one, this is the representation, my lord.
Page
Page to the, no, page 29.
29.
Yes, my lord.
From here, it has went to the commissioner, as my learned friend says.
Re-option under ROPA 29.
Yes.
Yes,
The
my lord.
petitioner, the grievance of the
19. 19.
yes, sir. The grievance of the petitioner is that that his prayer for re-option, re-option under ROPA 2019 is pending since
2020.
Since
January 2020.
Since January 2020. So stop. Mr. Mullik, learned advocate, appealing for the petitioner submits that the petitioner by a letter dated 27th of January 2020 requested the concerned district inspector of schools within bracket AC to consider the prayer of the petitioner for change of the date of option from 1st of January 2016 to 25th of July 2019. So he submits that though a long time has elapsed since the receipt of such representation, no decision on the prayer of the petitioner has been communicated to him till date. So the learned advocate appealing for the state submits that the matter is now pending before the Commissioner of School Education. To start paragraph, in the light of the submissions made by the learned advocates for the respective parties, WPA number 36 stands disposed of by directing the Commissioner of School Education, Government of West Bengal, being the fourth respondent, to consider the representation of the petitioner dated 27th of January 2020 and to dispose of the same by passing a reasoned order after affording an opportunity of hearing to the petitioner or his authorized representative and communicate the reasoned order to the petitioner immediately thereafter. First of the entire exercise shall be completed as expeditiously as possible, but positively within a period of 6 weeks from the receipt of a server copy of this order, together with a copy of the representation dated 27th of January 2020. So it is however made clear that this court has not gone into the merits of the claim made by the petitioner in the said representation, and all points are left open to be decided by the said authority in accordance with law.
One indulgence, the District Inspector of School Jalpaiguri vide the memo number 539 dated 5/3/2020, if that could be recorded, because from the instruction that is
The
there.
memo.
Or the instruction will be taken on record, Your Lordship.
The written instructions of the District Inspector of Schools dated 17th of July 2026, filed by the learned advocate for the petitioner, filed by the learned advocate for the state, is taken on record.
May I have a copy of that, or can I?
He only said that it has been, please give him a copy.
She doesn't have, can I take a picture and?
Please take a printout and give it. Yes, call the fixed matter. Yes.
Instruction.
One indulgence, my lord.
Yes, my lord. So what I was saying,
My lord, my lord is taking a fixed matter.
Yes.
That is 78.
So, my lord, can I make a humble request to the honorable court? I have 4 items before your lordship was of the same nature: 73, 74, and I think 79 and 80. If my lord can be kind enough to assign that on Monday, I will physically appear before your honor.
No. I am appearing for the petitioner. Lord, I am appearing for the petitioner.
Which items?
73, 74, 76, 77.
What are these matters?
Land acquisition matter, all are different. Lord. 76 and 77 may be the same, but the rest are different.
Yes, so Monday it will be taken up.
Lord, railway is not even a party. In item number 74.
74. All right, I'm making it. He wants that.
Lord, he is not a party, Lord.
He wants that to be taken up on Monday.
Yeah, other
maybe
matters
on
we are a
Friday.
Milord, it is a project of national highways. How can the railways seek for adjournment?
The state is then seeking.
No, my lord.
State is a party. Kindly takes it up on Monday.
Mr. Das, today you have a resolution at 3:30. This is a fixed matter.
Kindly take it up on Monday, my lord.
Don't overestimate the pace of the court. I cannot reach those matters after fishing.
The state is party to all the cases.
I'm not that fast.
I beg your pardon, Lord.
Yes.
Obliged, my lord.
Yes.
Yes, so what I was saying, my lordship, was on the last occasion.
My lord, all right. My lord,
I just wanted
before,
to draw my lordship attention upon.
my lord, before Mr. Mishra starts, my lord, may I make one submission? My lord, that is,
Yes.
my lord, on 4 counts, I have challenged the jurisdiction. Now, whether if Mr. Mishra wants to submit, I can respond to it later. And if Mr. Mishra wants to hear my side of the case, I may be allowed. It depends how he wants to go. My lord,
So the
I can
agreement
stay.
is that natural justice violation and additional time will not be taken. That those two will not be pressed as a ground. We
No,
will
no,
discuss
I am
our
not saying
jurisdiction.
that. I am going into the root of.
That is what we agreed on the
Yes.
last one. No.
I have never.
It has
I have
boiled down
not
to
agreed
additional
with,
notices and tab. Then to additional notices and tab. We have taken all points.
My lord, I have gone to the
Yes.
root of the case. My lord, may I make my submissions?
All right.
My lord, on the first day, my lord, I made a submission that whether the state has cross-empowered to pass adjudication order in respect of the matters of taxpayers who are under the central jurisdiction, and I have relied on a notification, and my lord, for which the CGST may respond by filing an affidavit that whether I can do that, whether the state can do that. My lord, my second ground, my lord, of challenging the jurisdiction is, my lord, the order has been.
Yes. Yes, yes.
My lord, the order has been passed. My lord, may I proceed?
Yes. Yes.
My lord, the order has been passed by the Bureau of Investigation, ITC Investigation Unit. My lord, my submission is neither the ITC Investigation Unit nor the Bureau has power to adjudicate. Now, my lord, I will show, my lord, place before you, your lordship, page 89, how the ITC Investigation Unit was created. My lord, which is at page 89.
Yes.
Yes, my lord. My lord will find that my lord, it was created by a trade circular of the commissioner under the West Bengal Value Added Tax Act during the VAT regime. Now, my lord, I'm reading the first paragraph. It is a trade circular. It has been found that there are several instances of tax evasion through false and exaggerated claims of input tax credit under the West Bengal Value Added Tax Act 2003 by means of bogus circular trading and fictitious transactions involving fake tax invoices or tax invoices issued without any corresponding transfer of property in goods or the like. Besides contravention of the provisions relating to claim of input tax credit, in some cases there have also been commission of offences under the said act as also under the appropriate provisions of the Indian Penal Code 1860. So it has been found necessary to create a specialized unit, my lord, I'm emphasizing here, to investigate into alleged cases of false claims of input tax credit, cases of transactions relating to excess claim of input tax credit, and cases of issue of tax invoices by dealers in contravention of the provisions of the West Bengal Value Added Tax Act 2003 and take appropriate actions as may be deemed necessary for the purposes of the act. So, my lord, it was created with the purpose of investigating into false claims. Then, my lord, with the above objective in mind, it has been decided to constitute a dedicated ITC investigation unit in the office of the Commissioner of Commercial Taxes, West Bengal, at such and such. So, my lord, it was a unit within the office of the Commissioner of Commercial Taxes. Then, my lord, the functions are the same, the objectives that were given, and my lord, so far as jurisdiction was given, my lord, it had jurisdiction throughout the whole of India, through all of West Bengal. Now, my lord, this was done by a trade circular. Now, my lord, to legitimize this, my lord, on page 91, on 28th of May 2015, a notification was issued by the Government of West Bengal Finance Department. My lord, it says that in exercise of the powers conferred by subsection 1 of section 6 of the West Bengal Value Added Tax Act 2003, the government is pleased hereby to specify the whole of West Bengal as the area over which any person appointed under subsection 1 of section 6 of the West Bengal Value Added Tax Act 2003 to assist the Commissioner of Commercial Taxes and posted in the STDS cell, Data Analysis Wing, and the ITC Investigation Unit in the Office of the Commissioner of Commercial Taxes, West Bengal, shall, notwithstanding anything contained in this department notification dated such and such, exercise jurisdiction for discharging of functions under the provisions of the West Bengal Value Added Tax 2003 and the rules thereunder. So, my lord, the trade circular says it was created for the purpose of investigation. Now, thereafter, they wanted to legitimize this by issuing a notification. Now, my lord, this was on 2015. Now, my lord, what happened when the West Bengal Value Added Tax, when the GST came into operation, my lord? My lord, I'm placing, there is, my lord, kindly come to page 83. My lord, page 83. 83, my lord. My lord, this was the notification given under, my lord, after GST came into operation. Now, my lord, at page 83, it says Government of West Bengal, Finance Department, Revenue. Number such and such, 21st day of June 2017. My lord, GST came into operation from 1st of July 2017. The governor is pleased hereby to declare that the charges, circles, large taxpayer unit, information system division, data analysis wing, central audit wing, central registration unit, central refund unit, STDS cell, central section, tax recovery officer, Bureau of Investigation, ranges, ITC investigation unit, and other offices, including administrative offices of the Directorate of Commercial Taxes, West Bengal, existing under the West Bengal Value Added Tax Act 2003, shall be deemed to have been set up under the West Bengal Goods and Services Tax Ordinance 2017 and the rules framed thereunder. My lord, by that time, my lord, the act was also not passed. It is under the ordinance. Now, my lord, so what has happened? What was prevailing under the West Bengal Value Added Tax Act by this notification and under the ordinance was taken up under the GST Act. Now, my lord, I will place the judgment whereby declaring that the ITC unit is illegal. My lord, kindly come to page 84.
Page
My lord,
84.
84, next page. Now, this, my lord, judgment was passed on 24/8/2021 after this notification. Now, my lord, I'm just reading this. Since common question of law is required to be decided, all these bunch of applications were taken up for hearing analogously and now being disposed of by this judgment, which will govern the aforesaid mentioned cases. My lord, I'm reading the next paragraph too. It is contended that upon receipt of notice under section 66 of the VAT Act, the petitioners came to know about ITC investigation unit created by the Commissioner of Sale Tax. On further inquiry, the petitioners came to know that such wing of the Directorate had come into existence with effect from 1/9/2014 through Trade Circular number such and such, such and such. Further contention of the petitioners is that through notification number such and such, the state government also conferred jurisdiction upon the said unit of the Directorate without constituting such wing according to the provisions contained in the VAT Act. So, my lord, this was the list, or this was what was under challenge, both the creation and the notification, my lord, by which it was sought to be legitimized. Now, my lord, I am reading the operative portion of the judgment, which is at page 95. Now, my lord, it says, my lord, let me read from the paragraph before that, my lord. We are not impressed by the argument of the learned state representative that the commissioner's power to transfer a case from one officer to another officer confers upon him the power to create territorial jurisdiction over the offices appointed under section 6(1). We do not also find ourselves in agreement with the learned state representative that the word may occurring in section 6(1) as discussed herein above is merely obligatory and not mandatory. On scrutiny, close scrutiny of the whole ambit of the statutory provision under the West Bengal VAT Act, and more particularly having regard to the creation of the Bureau of Investigation in terms of Section 8 of the West Bengal VAT Act, we are impelled to hold that the Commissioner of Sale Tax does not have the jurisdiction to create the ITC investigation unit. In the result, Trade Circular number such and such is found to be without jurisdiction and invalid and illegal. Now, after giving a careful consideration to the government notification, we are also impelled to hold that although the state government does have ample power to create any such unit, but in the instant case under the impugned notification, the state government has not acted in conformity with the statutory provisions contained in WB VAT Act 2003, and the said government notification is also liable to be declared as invalid. In the result, all the applications succeed and are allowed. The trade circular number dated such as such is declared as illegal, void, and invalid, being without jurisdiction, and the government notification is declared as invalid, being not in conformity with law, and the trade circular is found incapable of any ratification by the government notification. Now, my lord, the respondents did not appeal against this order before the High Court. Now, so what happens, my lord? The unit which is being taken over from the VAT Act and into the GST Act, my lord, that unit has been null and void from its inception. So once that unit goes, my lord, how it can be carried over to the GST wing? That is GST under the GST Act. So, my lord, and not only that, my lord, the ITC investigation unit under the West Bengal value added tax was created only to inquire, to investigate into alleged, my lord, issuing of fake invoices and claiming irregular ITC. Nothing more than that. That is my submission. So the respondents being of the Bureau of Investigation and ITC unit has no jurisdiction now to conduct any adjudication proceedings under the West Bengal GST Act, Goods and Service Tax. My lord, this is my second challenge to the jurisdiction. My third challenge to the jurisdiction, my lord, I must be candid. I'm challenging whether the Bureau of Investigation can conduct adjudication proceedings. Now, my lord, I must be candid. I have not taken this particular point in my writ petition. But even though, my lord, I have not taken this point in my writ petition, as I am not disputing any fact, but it is a question of law, my lord, it can be taken even at the stage of even Supreme Court. But before that, my lord, I will place before your lordship judgment of the coordinate bench of the Calcutta High Court, my lord, which my learned junior will submit before your lordship, that I may take up this question of law, even though I have not taken it in my grounds. My lord, kindly see, this is, my lord has the judgment. My lord. My lord, since it is not paginated, I have paginated, my junior has paginated with the hands, pen. Now, my lord, what was, my lord, the first paragraph. Learned Advocate General appearing in court of this application has stated before me that although various grounds have been taken in the petition, he will attack the validity of the notice only on two grounds. Namely, the notice is invalid as the notice does not indicate or mention whether BD Sarogi and others is a firm or HUF association or person, and the sanction of the commissioner is mechanical, and giving sanction, the commissioner has not applied his mind. The learned Advocate General has further stated that although he is not pressing the other grounds in this petition, it should not be considered that the other grounds are abandoned or are given up by the petitioner. According to the learned Advocate General, these two grounds are sufficient for the purpose of disposal of this application, and in that view of the matter, he has confined his arguments only to these two grounds. The learned Advocate General has fairly stated that ground number one, namely that the notice is invalid, has not been specifically taken in the petition. It is, however, his contention that although the said ground has not been taken specifically in the petition, he is entitled to urge that ground as the said question is a pure question of law and does not regard any investigation of facts, and the said question goes to the very root of the matter. In support of his submission that he is entitled to raise this ground without taking the ground specifically in the petition, the learned Advocate General has relied on a number of decisions of the Supreme Court and also of this court. Now, my lord, kindly come to page 5, the order passed by the court, my lord. My lord, last paragraph, last one paragraph. It is undoubtedly, my lord, page 5 of the judgment.
Yes.
It is my lord, just before the last paragraph. It is undoubtedly true that this point of invalidity of the notice has not been specifically taken in the petition. This question, however, is a pure question of law, and the question turns on the interpretation of the notice itself and does not require any investigation into any question of fact. The question of law clearly goes to the very root, as the point relates to the question of jurisdiction of the authority concerned. As the question is one of pure law and raises the vital question of jurisdiction of the authority concerned to reopen the assessment, I am clearly of the opinion that the petitioner is entitled to urge this question at the hearing of the petition. If the authority concerned does not have a jurisdiction in the absence of a valid notice being served, the entire proceedings will be without jurisdiction and void. And even consent on the part of the petitioner would confer no jurisdiction on the ITO. So, my lord, in this judgment, although this particular issue of jurisdiction was not taken in the petition, but it was allowed because it was a pure question of law. My lord, so I am stating that what I am saying is the Bureau of Investigation, it is apparent staring at us, and the Bureau of Investigation has issued the show cause notice and had also passed the order. Now, my lord, I'm also relying upon, in this respect, my lord, I'm relying upon a judgment of the Supreme Court, my lord. My lord, that is K.L. Lubna. My learned junior, my lord, will submit this. My lord, only kindly come to paragraph 10 of this. 10, paragraph 10 of this particular judgment. My lord, it related to a different matter. It related to a tenancy matter, and where certain points, my lord, only questions of law involved these things. These were involved. My lord, 10. On the legal principle, it is tried to say that a pure question of law can be examined at any stage, including before this court. If the factual foundation for a case has been laid and the legal consequences of the same have not been examined, the examination of such legal consequence would be a pure question of law. Then, my lord, paragraph 12. We may also usefully refer to what has been observed by Lord Watson in Commercial Fire Insurance Company versus Kavanagh in the following words. Where a question of law is raised for the first time in a court of last resort upon the construction of a document or upon facts either admitted or proved beyond controversy, it is not only competent but expedient in the interest of justice to entertain the plea. Of course, then he goes on to qualify, saying the expediency of adopting the course may be doubted when the plea cannot be disposed of without deciding nice questions of fact. My lord, I am not disputing any questions of fact. I am only raising this plea that the Bureau has no jurisdiction, my lord, to issue the show cause notice and also to adjudicate the matter, and also, my lord, to pass an adjudication order. Now, my lord, in this respect, it is clear that the Bureau of Investigation has no jurisdiction will be evident from the order dated 2011-2019 issued by the Commissioner. My lord, my learned junior will place that order before your lordship. And my learned junior may also give a copy to the other side. My lord, if your lordship sees. Now, my lord, it says, my lord has the notification order?
Yes.
My lord.
Yes.
It says, in exercise of power conferred by subsection such and such of 4 of West Bengal Goods and Services Tax Act, the Commissioner hereby specifies that the Senior Joint Commissioner of State Tax, the Joint Commissioner of State Tax, the Deputy Commissioner of State Tax, the Assistant Commissioner of State Tax, and the State Tax Officer posted at the headquarters and zonal offices of the Bureau of Investigation South Bengal and Bureau of Investigation North Bengal shall exercise jurisdiction as detailed in the following paragraphs. Now, my lord, paragraph 2, paragraph 3, these are the territorial jurisdictions of the Bureau. Now, my lord, kindly come to paragraph 4, which is very relevant and important. The officers, paragraph 4, the officers posted in headquarters or zonal offices of a unit of Bureau of Investigation shall exercise jurisdiction over any person, including a taxpayer, transporter, or person in charge of a vehicle, irrespective of the specific location of the place of business of such transporter or person, for carrying out enforcement activity. Minor enforcement activity in respect of storage of goods or transportation or movement of goods into, within, out of, or through the state of West Bengal, provided the goods are stored or the vehicle is intercepted within the territorial jurisdiction of the headquarters or zone of a unit of Bureau of Investigation in which he or she is posted. for the purpose of investigation, including ITC investigation, the officers posted in any headquarters or zonal offices of units of Bureau of Investigation shall have jurisdiction all over state of West Bengal in connection with or incidental to investigations relating to taxpayer or person having principal place of business over the territorial jurisdiction. So, my lord, their powers are limited, confined only to the point of investigation over their territorial jurisdiction. They do not have power, my lord, to adjudicate, to issue show cause notices under section 73 or 74. My lord, in this matter, my lord, I'm relying upon a judgment, a coordinate bench of this judgment passed by the principal bench as late as 8th of July 2026. My lord, my junior will place before your lordship
Yes.
WPA 14040/2026. No, my lord. My lord, there, my lord, the show cause notice was challenged. In my case, the show cause notice has, my lord, culminated into an adjudication order. Challenging the show cause notice issued by the respondent number one, that is, my lord, the Joint Commissioner of State Tax Bureau of Investigation, South Bengal and others, in his capacity as Joint Commissioner State Tax Bureau of Investigation for the tax period such and such, on the ground that though he has the jurisdiction to invest into non-payment, short payment of taxes by notification dated such and such, same does not empower him to issue the show cause notice. Mr. Kanodia, learned advocate representing the petitioner, has not only drawn the attention of this court to the provisions of Section 73 of the WBGST CGST Act of the said Act, but also to the notification which came into force with effect from 1st December 2019. By referring to the above notification, he would submit that the same deals with the jurisdiction of the officers posted in the Bureau of Investigation and has been issued in exercise of powers conferred by subsection 2 of section 4 of the said Act. According to him, the clauses 2 and 3 of the said notification deals with the territorial jurisdiction of the particular officers, where clause 4 deals with the extent of the jurisdiction exercisable by such officers. And then, my lord, the honorable judge quotes the paragraph 4. Then he comes. Having regard to the aforesaid, the next page, it is submitted that since the same does not confer any authority on the respondent number one in his capacity as Joint Commissioner of State Tax Bureau to issue any show cause notice under Section 73 of the said Act, the proceeding before him is a non-starter. He submits that an identical set of facts, a coordinate bench of this court, my lord, all the cases that has been referred to, has entertained the writ petition. Accordingly, he pays for interference by this court. Mr. Ms. Agarwal, learned senior advocate, appears on behalf of the state. She would submit that an opportunity should be afforded to the respondents to file an opposition. At the same time, it is also her submission that since a show cause notice has been issued, the proceeding should not be stalled. Now, my lord, having heard the learned advocates and noting that the jurisdictional issue has been raised, and on the basis of the prima facie case made out, I am of the view that the writ petition should be heard. However, at the same time, taking into consideration the fact that the show cause has already been issued, it would be prudent at this stage to direct the petitioner to not only respond to the show cause notice, but also to participate in such proceedings. The respondent number one shall be at liberty to decide on the proceedings. However, such order shall not be enforced insofar as the petitioner is concerned till the disposal of the writ petition or until further order, whichever is earlier. The respondent shall be at liberty to file affidavit in opposition within 4 weeks, reply if any thereto within 2 weeks thereafter, and liberty to mention after expiry of the period for exchange of affidavit. So my lord, my humble submission would be on the similar principles of law. The coordinate bench has admitted the writ petition, but because they had challenged the show cause notice, they were directed to go and appear in the proceedings, but the order would not be given effect to. My lord, my submission is that my show cause notice has culminated in the adjudication order. But since the Bureau of Investigation has no power to adjudicate the matter, my lord, So I am praying that if the respondents want to file their affidavit, they are, my lord, they are liberty to file the affidavits, but my lord, the order may not be enforced. And meanwhile, my lord, I'm also trying to state that the revenue will not suffer any loss because, my lord, the petitioner was not guided properly. He filed an appeal. The appeal was, at the time of filing appeal, he paid 10% of the disputed tax, which is 3,83,420 rupees. So in that respect, my lord, the revenue is also secured. But I am now, my lord, the appellate authority, my lord, dismissed it on the grounds of limitation. I am not praying that it may be heard by the appellate authority. I'm saying since it goes to the root of the Liz, my lord, let the writ court, my lord may entertain this writ petition. Apart from this, my lord, my fourth ground is also relating to jurisdiction, which the respondents will be able to. My lord, they have invoked section 74. That is, I have obtained ITC on the ground of fraud, willful misstatement, or suppression of facts. But my lord, nowhere in their show cause notice they have made these allegations against me. The only allegation made against me is that I have received supplies from registered taxpayers whose registration has been cancelled retrospectively. And my lord, of the five suppliers, my lord, in the final order, they have deleted the demand which they made in respect of two suppliers. And of the three suppliers, my lord, their registration was cancelled because they had obtained registration by means of fraud, willful misstatement, or suppression of facts. My lord, I do not know how they have obtained their registration. I had done business with them at the material time the registration was valid. So I should not be punished for them for their fault. So, and therefore, they ought not to have invoked section 74 if they felt that any tax was to be recoverable from me, my lord, it should have been done under section 73. My lord, this is my submission.
Yes.
But on your place, the goalpost is getting changed. The goalpost is getting changed.
Only one thing, Mr. Misro,
If my lord, ultimately the argument is going to happen around that the natural justice has been violated and 73 and 74, then we do not need to.
no, not only natural justice, she's
else.
questioning the jurisdiction.
If she questions the jurisdiction, we will answer my lordship on jurisdiction.
Yes.
Then she cannot question anything else. Because this is all coming from the bar today.
No, if you want to file affidavits, you can file your affidavits. If
she restricts it on 2 points. One is, my lordship, regarding the that special unit that is there. That has been declared to be wide ab initio or whatever we will deal with it.
Only one thing, here an adjudication has been made.
Yes.
Now, they have preferred an appeal.
Yes, my lord.
In the appeal, they have put in that prerequisite, pre-deposit, whatever is there.
10%.
So now, if this is decided on affidavits, where is the harm? Because a coordinate bench has also noted on this prima facie at that stage said that yes, reply to the show cause notice can be done, but the order shall not be enforced. So now here it has culminated into an order. So don't enforce because you are also protected that pre-deposit has also been made. Here that is
Only
also
10%. Only 10%.
That is there. So now this is to be decided. So pending that, if you recover the entirety, what remains to be decided? File your affidavits, it can be decided.
90%
recovery, 90%. Specific.
What do you say?
But I was hopeful that based upon the agreement that we had on the last date of hearing before my lordship, there are 2 vital issues that they have raised. One is regarding the validity and legality of the ITC intelligence unit. And second is whether CGST, a person who is registered under CGST can be noticed or summoned or proceeding against him can be carried out under SGST or not. We were prepared on that point. Now, if somebody...
Yes, that is what I am telling you. You can take time on that. There is no difficulty. But,
But where is this case made out? What will I reply to in the affidavit? Because in the writ petition, the case is not made out. Neither is there a supplementary.
that is why she has referred to that decision,
that
well settled proposition that if
But
it is
that-
a question of jurisdiction can be
That's
taken at
true.
if it
But
is a point of law.
my lordship knows there are other judgments also that say that if because they are represented by a lawyer. So if it hasn't been specifically pointed out in the writ
Only
petition,
one thing, Mr. Mishra, it's well settled. There are several decisions on that. If it is a point of law, it can be taken at any point of time, even for the first time before the Honorable Supreme Court. That's well settled. That's elementary. But provided there is factual basis or foundational factual basis in the pleadings with regard to that.
73, 74.
So now
What is
they are
taking today?
challenging, they are challenging only on the basis of the circulars that this Bureau of Investigation, they do not have the power to issue a show cause notice, and
That we will answer now and here. That we will answer now and here.
So,
But as far as 73 and 74, the interoperability is concerned, that is not there in the writ petition.
It is
So
there,
my lord
my
will
lord, it is
decide it
there
as
in the
it
writ
is.
petition. It is there in the writ petition. My lord, I'll show it to your lordship. I have taken this point in the writ petition. My lord.
that
I've
she has
taken it.
taken. Now what do you say?
I'm pressing it before your lordship, my lord.
Yes, Mr. Mishra, if you want to
My lord, my
file
lord.
your affidavit,
Ground 15, my lord, at page 32.
I will call 74 decline.
ground 15.
15.
Taken only in
For
the ground.
that, ground 15 in page 32. For that, even otherwise, the adjudication order is illegal. The respondent number 1 has traveled beyond the show cause notice and proceeded with malafide intention to pass the adjudication order without establishing any of the ingredients of fraud, willful misstatement, and suppression of
She has
facts,
also
which are
challenged
the
on merits
prerequisites.
Apart from the jurisdiction point, she has also challenged the merits.
Section 73.
If you
has
want
not-
to make submissions, I can keep it on another date. Or if you want to file affidavits, that is also there. What do you want? I'm keeping it on Monday.
My lord, only one thing, my lord. In page number 112, they have issued a recovery notice subject to my
that should be
senior
stated.
submission. Now, that is staring at my face.
Yes, that should be
And
stated.
if your lordship kindly
That should be stated.
stay the demand, otherwise
And then the matter
will
will
be in
go in
great
the list and then we will have to.
Extension, one after.
Very true.
That because if you give an undertaking that you will not proceed. with
And the
it.
amount is also very, I mean, very small amount, only 1 crore 46 lakh.
that is very
Yes.
small.
No?
No,
Isn't
no, that
small?
is the total. The tax is, my lord,
That is the
38 lakhs.
total
Tax is
amount.
38 lakhs.
Amount.
The
Tax is
tax is
38
38
lakhs.
lakhs.
So, my lord, the idea is that other than natural justice and other points, take certain points around circular and everything, traveling from the VAT Act till today, get a stay from the court, affidavit would be directed, and then the revenue will never be able to recover things. Because we all know
My-
hearing matters have not been taken up.
My lord, if the
Very noble thought. And all this has happened because of an accountant. There is a very
My
beautiful
lord, it
story
has
that has been
nothing to do
portrayed
with
before
the
my lord.
accountant. My
No,
lord,
ma'am,
all this.
you have been, madam, when you talked, madam, I was sitting here, madam, I didn't say anything.
I'm sorry.
There is a
I'm
very
sorry,
beautiful
please
story.
make yourself.
There is a businessman. He is a villager.
So if you want, I can keep it on Monday.
No, just for a moment. There is a businessman. He is a villager. He is a very godly person. He has built 4 temples on 4 corners of the village. There is scented essence that is blown. He hasn't done anything wrong. Never tell a lie. Then comes a demon. He is his accountant. That accountant, he is the most third-class person in the world. What he did was, he didn't inform him. And that accountant is not a party here. We do not know what the stand of the accountant is. That accountant, the third-class person, he did not inform them. And because of which today they are here. And the worst part is that the accountant used to operate the email ID and the password was also with him. So today, neither the accountant is party, nor we know what the stand of the accountant is, nor we know whether they have taken any disciplinary proceeding or any proceeding against the professional, because he is covered under the ICM Act, Cost Accountancy Act, Section 29 thereof.
mere accountant. He's a mere accountant.
I'm mere accountant. I'm saying that he is the demon. He is the demon of the story.
If the foundation
He is the
of the
villain.
proceeding
So-
is
So
under
what is
challenge.
happening is that everything you put up on the accountant, because the accountant is not there. They could have come with the
kindly
IT
appreciate
log
if
of the
the
email ID
foundation
where
of
it was
the lease is
operated. That did not come.
under question.
They will not make the
then-
accountant the party.
Mr. Only one thing,
My lord.
if the jurisdiction is not there, then everything.
We will argue on jurisdiction. We always wanted to argue on jurisdiction.
All right, come on, Monday. Yes.
But everything will fall down to that accountant.
Ms. Mukherjee Lanet, advocate appearing for the petitioner, made further submissions in support of our contention that the authority passing the order of adjudication lacked jurisdiction to pass such order. So stop paragraph list this matter on Monday under the same heading to enable Mr. Mistro give reply to the submission.
My lord, if the matter may be fixed at,
The hearing matter, it will